Services UK Limited in relation to a permit variation under the Pollution Prevention Control Regulations 2012. This hearing is being webcast live and can be observed later on, and if parties need to access it and look at the webcasting, that can be found on the DPA website and by searching under reference ENVE-003-255, where all the documents there are being held. My name is Paul Coquette. I'm a reporter appointed by Scottish Ministers on a delegated basis to decide the appeal, and a hearing has been set for today and tomorrow, with a continued hearing on a basis not finally decided yet to take place on the 4th of March. On that basis, I would invite, I think on my right, counsel for the appellant FCC to introduce her and her team and then come to SEPA. Thank you.
Thank you, sir, and good morning. My name's Ruth Crawford, King's Counsel, a member of the Faculty of Advocates. I'm instructed principally by Charlotte O'Kane and also her associate, Rebecca Miller from Pinsent Masons, and representatives from the appellant are also present today. That's Ian Martin, Kelly Toon and Felicity Fisher. Sir, I don't know if you wish them to give short biographies.
No, that's fine.
Thank you.
Good morning, Josephine Armstrong. I'm Senior Solicitor within SEPA, representing SEPA today, and I have a number of colleagues with us here today that I'll just introduce, starting from the top of the table. We've got Dr. Claire Neal, who is one of our principal scientists within SEPA, Andrew Hemingway, who is one of our water specialists within the permitting team within SEPA, Olivia Downey, who is another principal specialist scientist within SEPA, specialising in chemistry. Then I've got, to my left here, Stephen Devlin, who is a senior environmental protection officer within the landfill regulation team. To his left is Richard Birch, who is the unit manager of the landfill regulation team. And finally, we also have Raymond McDermott, who is also a specialist within the landfill regulation team.
Okay, thank you. I think in previous correspondence we've not identified any other parties of an interest in the matter in the appeal today, and so we're proceeding on that basis. As I say, the events are being recorded here, proceedings being recorded here, and that will allow us to view anything that is beneficial in gathering the evidence together at some point in the future. First and foremost, for me, the recording of these hearings are beneficial. It allows me to concentrate to a greater extent than perhaps in the past on what's being said at the hearing itself, without having to scribble down every single note. However, you may still see quite a lot at the top of my head as I do take notes as we go. So forgive me for that. The proceedings here are to a degree formal, but nevertheless I would encourage as much informality as is possible in the circumstances, in trying to get an understanding for me as I go through the process, largely leading questions on the various topics on the agenda, which I'll come to in a moment. I have to say my general approach to hearings is to be reasonably relaxed in terms of where questions and issues arise from. All the questions will be asked of parties formally through me, but if agents for the parties wish to be asking for clarification or raising any issues, they should feel free to do so, and don't feel we want to be too formal in that regard. As I say, we have hearings set for today and tomorrow and the 4th of March, all located here. The intention to start, if this works for parties, at 10 AM on each day, and I'm planning on having a 1 hour break at lunchtime, probably at 1 o'clock. I think you have had some information given to you. We're a bit short of local places for dining for lunch, but I think you have maybe have some indications where you can go for a sandwich or a coffee, if nothing else. If anybody wants a break at any point to take instructions or anything else arising at any point, just say we can stop. I was planning on taking a short break at 11:30, as I like to do mid-morning, and my intention would be to sit till 4 o'clock this afternoon and do so for subsequent days. I myself have a bit more flexibility to go beyond 4 o'clock, but others may not. So we'll just see how that works out, and play that by ear. As I say, the first 2 days were set for today and tomorrow, are hearing sessions, and we have a further date set for dealing primarily with ecology issues, and I was grateful to all parties for submitting the precognitions, three precognitions, which were received yesterday, which I've read. I'm expecting that most of the evidence in relation, disputed evidence in relation to ecology and perhaps related question, I want to say a little bit about the chemistry data, will be addressed when we reconvene, which is in one sense slightly the wrong way around, but it is inescapable because of issues of witness availability. But that's all fine. What I would like to spend time, probably tomorrow, rather, I think the appellants of a further witness coming tomorrow, Mr. Mail, I think. But what I want to do in relation to that evidence there is effectively using the time today and tomorrow to look at the legal consequences of the ecology evidence, such as it is, as we look at later, and I'll address this in a bit more detail as we go, look into and get a better understanding of some of the history of the discussions. The technical stuff, I think, can probably be left until witnesses have been able to speak to their precognitions and provide information. But I have a number of questions about the history of how we are at this situation now, having had concerns raised, as I understand it, going back 6 or 7 years, and responses by those instructed by the appellants in relation to ecology. So some questions I'd like to address at this stage to give me a framework of understanding the significance of the ecology evidence and the significance of the finding and historical findings as to the state of the various stretches of water concerned. I know there are several different stretches of water that are a matter of dispute, but I'd like to get a better understanding of the history of how these matters have been raised, and specifically find out a little bit more, get a slightly deeper understanding about the steps taken to try to gain a common understanding between parties as to the condition of the water. I accept that it's not always possible to achieve an agreement and common understanding, but if it's possible to do so without those witnesses being here, then I'd like to do that as far as I can. The second related matter in connection with the evidence, in particular the sort of chemical data as to the most up-to-date current position, which was provided, I think, about 2 weeks ago from SEPA, with further information provided by the appellant on Friday, and I'm very grateful for that, and that was very helpful. I've been looking at the evidence really in 3 parts. You know, the sort of the not the ancient history, but the initial history around 2019, 2020. The most updated information at the time when a decision to make the variation occurred, and then the update up until the information we have just now. And I was grateful for the information provided, the chemistry data provided as the most up-to-date position, giving a snapshot of where we are now. If it hadn't been provided, I'd have asked for it, because I'm quite keen to get that information in play. One thing that I would find useful when we come to considering this evidence again on the 4th of March, is that there was chemistry data provided by SEPA on a one-page document that they submitted about 2 weeks ago, with some information missing. I understand that was information that SEPA were aware of, but was missing and was provided by the appellant on Friday of last week. 3 documents produced in a spreadsheet with chemistry or chemical information that was in 3 quarters, quarters 1, quarter 2 and quarter 3 of 2025. What I would like, if it's possible, maybe when Mr Mail's here tomorrow and is able to speak to SEPA, is I know we're not dealing with it today and tomorrow, but I didn't find it particularly easy to look at that data and understand it in its presentation effectively in a different form from what SEPA had provided. I'm not saying there's a right or wrong, but the information on the spreadsheets that were provided, I think it was 3 or 4 pages on each spreadsheet for each of the quarter that the information was available. It would be helpful when we could reconvene on the 4th of March if there's a common way of reading that information, even if it's disputed. I think I would find it easier to reach a view on relation to the information that's been provided. As I say, if we're not looking at it today or tomorrow, which was always my intention, to try to keep the scientific evidence and the ecology evidence in one place, which is why I was suggesting we deal with that on the 4th of March. But it would be helpful if parties could note that a discussion might be useful. And I say that not least because, again, very grateful, there was a joint minute of agreed facts that was produced in around end of October, beginning of November. This information obviously postdates that because it's up to date information provided since then. But if it was possible to update the agreed facts on a basis of which that information is available, that would certainly would be of assistance.
Sorry, would it help just by a point of clarification on that data that was provided? The summary table that was provided by SEPA, any references within that to not available, those were actually, it's not that is missing data, that is actually data that wasn't required to be submitted by the appellant. So it's really taking a summary of the 3 spreadsheets that the appellant has since submitted. That is what's submitted to SEPA, and we were just drawing out the relevant data for the parameters that are covered in the permit at present. So it was just to clarify it wasn't missing data. Yeah.
And my understanding from the appellants is that that information was known to SEPA.
Yeah.
Yes, indeed, and that's why the spreadsheets were presented in the way they were, because the inference seemed to be drawn that the appellants had not provided information which they ought to have done.
No, I understand that was an issue that arose, but that certainly be very welcome. Okay, thank you for that. The second introductory thing I was going to say, which again we've covered to a degree in correspondence, and has proved very helpful in looking at the timings of these issues. I know there are concerns from SEPA as regulating authority, is that I'm certainly proceeding on the basis that effectively the only matter in dispute is the content of Table 13 in the revised permit. We have an advantage that that's not due to have effect until the end of March of next year. I'm conscious that SEPA gave 2 years for an implementation period, but because of the circumstances that have arisen, we've now come close to losing 1 year of that. But I'll address that in a minute in terms of what can be done by way of modifications. But it is helpful to have that understanding that that's the area of dispute that's narrowed, and has been indicated, I think, on behalf of the appellants, and was indicated to me at the site visit, that the appellants are in compliance and intend to remain fully in compliance with all of the parts of the permit, including Table 12. So again, grateful for that. I've been trying to circulate an agenda really to help channel things in my mind into what appears to be a series of various different aspects of the subject matter of the appeal. I hope that's helpful to others. It's certainly been helpful to me, and we'll go through that just in a moment in a way that is hopefully helpful for discussion. I do recognise that the issues there are not totally able to be separated out, and there'll need to be a bit of flexibility, and I'm very happy if parties, when we get into the meat of some of the issues we're discussing, if there's particular ways in which you want to present arguments to me based on the written representations, that's the appeal document, the response to the appeal, and then the appellant's further response. I'm very happy to be flexible on that. And as I say, we have a joint minute of agreed facts, at least as the date in which it was it was submitted. It will be useful to me when going from these discussions to get a clear indication when people are referring to particular pieces of evidence. We have a document list which I've been assiduously trying to keep up to date. Thank you for your assistance in all of that. But it would be useful if parties are referring to the documents that are lodged there, and in particular extracts in pages from those documents or sections from those documents that they indicate what those sections are, so that I can go and look at that. We may be looking at them in detail as we go, and part of this I think may relate in fact to some of the evidence we heard on the 4th of March. Now I think it's pretty true of both sides, but as I say, I was grateful for the precognitions lodged yesterday. It would be quite useful, particularly I think it's the precognition from I think Rachel Mackay-Austin who lodged yesterday, and there's a number of academic pieces that are lodged in relation to her evidence, which we'll examine on the 4th of March. But if there's bits of that she's specifically drawing from, an indication of that, so I can read that in advance, will be quite useful. Right now it's simply a list of something that's relatively extensive, and certainly technical information that I claim no particular expertise on. It's true for both sides. If there are documents or references to that I need to read in advance of the 4th of March, that would certainly help proceedings that day and make things much easier for me, which is helpful.
If I could
yes,
just,
of course.
sorry, preliminary issue on the documents you're referring to. We've got the updated document list that was usefully circulated yesterday. It was just to point out that certainly in SEPA's original submission from last July, the references within that are to the original numbering as was provided. So where we refer to that, I'll try and update to the current document list. Thank you.
Switch on again. Information that is as up to date as possible, and tied with that is something that I've encouraged before, and I'd like to understand a bit more about the parties' positions. Is that that this is a determinative process. So I'm not a mediator, but nevertheless, I'm quite keen to encourage as much common understanding of agreed facts as possible, and we'd encourage you to continue to do so. And lastly, by way of introductory comments, I'll just reiterate what I said about closing submissions in correspondence. It might be useful at the close of 4th of March, probably more than tomorrow, if parties do want to say a little bit about what they've said already. I'm thinking of legal agents here and representatives on what they've said before. But my intention is to broadly get to the end of the evidence session and then give time for parties to think about closing submissions, so they're not expected in detail at the end of 4th of March. So if that provides comfort and assurance to council and agents, that I'll not be expecting them to turn around and summarise where they are on that, and the period we give for closing submissions will depend on where we are at that particular point. Okay, right, that's all I was going to say by way of general introductions. As I say, I'd circulated an agenda which hopefully can help steer our discussion. I don't know if either representative has any comments on the agenda as such.
Yes, I was going to suggest that we might consider perhaps a change in order of items.
Yes.
Just in terms of the way things flow logically, we felt that it was perhaps better to take items 3.5 and 3.5A ahead of item 3.4, since that deals with the actual calculation of limits. So we felt it was better to go through the actual decision-making process, our justification for why we felt limits were necessary before we actually get into the detail of how we calculated
How they're
those limits.
calculated. Yeah. And if there's any view on that? Certainly, I'm quite keen to have a good understanding of the interrelationship between the BAT conclusions and the reason why apparently higher expectations and higher figures are being applied. Is there anything else on the agenda?
No, not
Sorry.
for my part, sir.
Thank you. Okay, thank you. Again, I found it useful to go and see the site. There was nothing particular that arose from me at that site. I think there were 2 additional plans that were provided that you may want to talk to, that Stephen may want to speak to in the course of the hearing today. I found the site visit was useful. Just seeing the operation of the appellants and the way matters operated, and had an opportunity myself to ask a number of questions around some of the practicalities of the site in its particular location and in its context that were there. Okay, so that was helpful. In the general issues section of the agenda that I'd raised,
Sir, apologies. Are you moving on from 1.2 already, or?
I was going to go on from unless there's anything else.
I was just going to reiterate what you were saying. It was very useful for the site visit, and certainly to have that from my perspective as well. As you mentioned, we've lodged 2 maps, SEPA 24 and SEPA 25, which I had contacted case officers in advance to see if there was an area to put those up, just because I felt it would be really useful throughout the discussions. We have brought some big, but she did mention it was the whiteboard, which is at the wrong end of the room perhaps for referring to, so I don't know if it's even worthwhile on that table in front of you for points. And just to perhaps reiterate like where we walked through on the site visit and the points we saw, because I think particularly when we get to talking about the evidence and the sampling points, it's really key to, I think, have that in front of us. So if I could maybe just bring these out and...
I'm not sure where that in the agenda would be the right place to do it, but you can put them out there.
Yeah, I thought just in terms of matters arising from the site visit, just to recap on actually where we visited on the site visit and those points, if that's useful, because I don't think anyone from the appellant side here today, apart from perhaps Sam, was there. So.
I'm not recognising
I have to re-roll those just to make them flat. Oh, that's a good idea. Maybe actually alright. I think it's alright. You can see it, but perhaps if I just quickly hold this up and talk through it. all around this way, but we drove back
Yeah, we did.
to the point where we could
There's an edge
see
of
it
town,
coming
wasn't it?
under that road,
Yeah.
and then we separately drove again up to this
That
point
point
up here,
there.
isn't it, Stephen? Yeah. And that is also showing then WPH is the upstream control point.
And did we go to that upstream point? Did we go as far as that?
No, I think we walked up
walked-
to about
yeah.
so there's a school up there.
Yes,
Yeah,
well, you
so
walked close to the school.
yes, we did actually.
Yeah.
We did almost get right into WPH, opposite the school. So just to show, and just I think just in terms of references when we're throughout
Looking
today,
at the
it will
if you
be referring
stick
to
that on
these
there.
different points particularly. So just to get an appreciation of distance
Okay,
and
that's it.
where everything is.
And sorry, sir, for clarification, did you visit any of the other points which are referenced in the report, such as WPC, through up to WPI, other than WP?
I think only
the
went to
control-
those ones.
Yeah, thank you.
Right, so thank you for that update on the plans and consequences of the site visit. Going on to the general issues, and that I think is probably for legal representation, I suspect, or representations on these issues. One of the issues arises in relation to Regulation 58 of the of PPC, and that relates to the power of modification that's available to me, and I think the appellants had drawn attention to other aspects of different appeals where the power to amend exists, but not the power of modification applicable in this appeal doesn't appear to reference the power to amend. And I was going to invite, starting with the appellants, for their representations on what that means in practical terms for me, and whether they can throw any light on what the difference is between modifications and amendments in these purposes and where it leaves me.
Thank you, sir. And reading the response from SEPA, I don't think it's in dispute that you have effectively, as far as this appeal is concerned, two options: either to affirm the decision or to quash. That provision is provided in FCC document 16D, that's Regulation 58. Which provides the appeal provisions, and a person who's served with a variation notice in this case may appeal to the ministers, and of course it's delegated to you, sir, that appeal. And then subparagraph 4, on determining appeal against a decision of SEPA, the ministers may, reading short, affirm the decision and see where the decision was as to the conditions attached to a permit, quash all or any of the conditions of the permit, and so on and so forth. Now, as sir, you are aware, and indeed was flagged up at the outset, sorry, on determining appeal subsection 5, the ministers may quash or affirm the notice, and if affirming it, may do so either in its original form or with such modifications as they think fit. So it appears, with respect to me, that the options are to quash or affirm, but if you are affirming, you may do so in its original form or with modifications. So there is a modification power available to the ministers. As you're fully aware, and as the appeal flagged up from the outset, the appeal is only made in relation to Table 13. And as you're also aware, the appellants are complying with the variation, and they're even complying with Table 13, not least because it doesn't come into effect yet, and they will continue to apply with all matters within the variation pending determination of this appeal. It suggests, as you're aware, sir, also there is at best what can be described as an arithmetical error in relation to the calculation of one of the limits of one of the chemicals, and it's suggested that there's by SEPA that there's a number of ways which to deal with that if you, sir, are minded otherwise to affirm the variation. I leave it to SEPA to make their submission in relation to that. But on the face of it, it would appear that if you are affirming the decision, you could modify to make that alteration, revision to the maths, as it were. Likewise, it seems to me that if you could affirm the notice, and by doing so modify, if you're minded to support the appeal so far as Table 13 is concerned, you could modify Table 13.
And there's two aspects of that that are in my mind. One of which is if the evidence is such that Table 13 in modified form is an appropriate thing to do, as opposed to saying Table 13 really can't be justified whatsoever, we're going to stick with Table 12, as to what potential alternative levels are appropriate there. And the other alternative modification that's in my mind is the question as to whether there is now, because of circumstances, nobody's fault, because we're in a situation where now it may well be the case, and those instructing your position, you may well be saying, even if we did things, we can't do this by 31st March next year, or whether a power of modification would allow a later date to be substituted for that, if that was thought fit.
I dare say that's possible, sir. So far as Table 13 is concerned, in suggesting modifications as far as Table 13 was concerned, I had more in mind of putting the red pen through it, but equally it'd be open to you, sir, to put in alternative figures, or indeed put in a later date.
I did slightly wonder in trying to work out what the difference between modification and amendment might mean, is that it might not be open for me to say drop Table 13. I'd have to reject the whole variation and ask SEPA then to start over again, which is not impossible to do, and may not be entirely inconsistent with the position on the ground.
All I can do is point to Regulation 58.5. For the avoidance of doubt, the appellant don't wish to be difficult if you, sir, are with them on their appeal, because the vast majority, the overwhelming majority of the conditions in the variation, there's no issue taken with those. While we're on this item of the agenda, you, sir, raised the scope of the appeal, and for the avoidance of doubt, it's certainly the position of the appellant that this is a merits-based appeal as much as one which raises issues of law. And obviously, I think that's obvious, seeing that we're having evidence. And it's not whether or not SEPA were entitled to come to the view that they were, but it's whether or not, having regard to the legislative framework, Table 13 is, in all the circumstances, appropriate. And again, that's reflected in the appeal document for the appellant. There are a number of issues raised in that appeal document. Some of them are law, but some of them go to the guts of the matter.
When it comes to that point, which it will in a minute, I'll ask SEPA to speak on this topic. That was one of the questions I wanted to kind of understand better, is that bit about some issues arising are issues of law, including particular the correctness or not of reliance on the directions, but most of the issues involve degrees of discretion, effectively, or judgment or assessment of the evidence. And I want to explore a little bit about what parties think is the appropriate approach for me to take in that respect.
Well, if I can just follow up on that, sir, it would be the position of the appellant that, insofar as you've described it as issues of discretion, in common with any planning appeals, it's an appeal to you, sir, to determine, delegated to you to determine, and it's for you to exercise your planning judgment on those matters, rather than whether or not the discretion exercised by SEPA was within the broad range of acceptable responses to that discretion. So, in short, the appellant's position is that on Table 13, the matter is for you to determine, having regard, of course, to the overriding statutory framework and the facts as you find them to be.
Just sticking with modification just now, I want to come back to that in a second, but sticking with modification just now.
Thank you, sir. As you've identified, I think parties are agreed on the legislative basis under the powers here under Regulation 58.5, in that that power to modify only applies if you are affirming the notice, which I would suggest that if you were minded to be looking at taking out Table 13 in its entirety, given that that is purely the scope of this appeal here, that would not be affirming the notice. In terms of, just to clarify as well, that in terms of the scope of the appeal, it is also against condition 8.56, since that is the one that has the time within it, so it's not just the limits.
There are consequential, yes, I think that's right. We need to formally recognise, identify that it isn't just taking out Table 13, there are various bits of associated consequential implications of that, so that's correct.
But in terms of that power of modification, it is a broad power, as you think fit, is the wording in the legislation, and therefore it's our position that it could be used to, if you were looking at changing the limits themselves or changing the date, it could be used, and similarly it could be used to amend the error that we have identified. If you weren't minded to use it for correcting that error, as we've stated in our submissions, SEPA would, at the earliest opportunity following the outcome of the appeal, we would seek to vary that on our own basis anyway. But I think that it's open to you to do that for us.
That's helpful. But just going back to the question of the nature of the jurisdiction, and I think that's helpful from what's been said thus far on this. I was intending to ask for views as to what the nature of the appellate jurisdiction is in this context. I mean, Regulation 58 does a lot of things, but it doesn't particularly give in detail guidance as to what the person appointed on appeal should do. And so I was interested in views on whether, like a planning appeal, I'm making a decision completely afresh, regardless of what SEPA have done before, or whether I'm looking at the circumstances and saying that if I think SEPA have got it wrong, effectively I send it back. I allow the appeal in completely and send it back for them to redetermine, sort of like a judicial review, but not quite, or whether for issues which there's discretion which has to be exercised properly, my role is to reach a view as to whether the SEPA were right or wrong in what they did, and if they were wrong in what they did, then substitute my own view. And in effect, insofar as there is scope for discretion in terms of what's done, exercise my own discretion. So it's really looking for views of parties really in that sort of territory. The significance of that we may come to when we deal with other parts of the appeal. But if and I think some of the issues that I thought were initially going to be raised by the appellants as to the non-disclosure of information at an early stage, but things have moved on from them. So I don't think those issues really they remain live anymore. But I think what I'm taking from the appellants is that they would consider that in effect I'm deciding this matter. I'm to decide this matter afresh, and that includes the question about if there's assessing the evidence and assessing, for example, SEPA guidance and SEPA policies in reaching a view as to whether what the right figure is, rather than a kind of judicial review type discretion, where I'm looking at whether I think that SEPA's decisions are out with the range of normal discretion decision making, and I'd only substitute my own view if I think they are out with that range, or whether the appellants think that I am really looking at this wholly afresh, and therefore have to step into the shoes completely of SEPA. I don't know if the appellants want to say anything more. You've said you've just nice to on that, but I just wanted to expand a little bit on just the question in my mind.
Thank you, sir. The primary position of the appellants is that you, sir, are looking at this afresh. And I do note in that regard that there's a further appeal from your decision figured in Regulation 58 rather to the Sheriff by way of summary application, which tends to suggest that it is a merits-based appeal. There may be a halfway house, but as I said, not so much a JR plus might be a way of putting it, rather than simply being confined by the normal constraints of judicial review and irrationality and the like. But as I said, the primary position is that it's a merits-based appeal, which does, as I indicated a moment or two ago, does also have legal arguments behind it as well. And again, for the avoidance of doubt, it may be relevant when we come on to, or when you, sir, come on to consider the argument of proportionality, for example. It may be appropriate to consider, and indeed I see that part of the agenda does refer or reflect that the decision-making process may be relevant. In my respectful submission, the decision-making process is relevant because the fundamental point behind this appeal is what was the basis for arriving at these limits in Table 13, which has a number of facets to it: legal, exercise of discretion, factual. And with apologies to those who've had to read the appeal document was trying to cover all those bases, and it's recognised that they do shade perhaps one into the other. There are. And with apologies if that wasn't made clear, but that does reflect the submission which I'm making, is that this is effectively a merits-based appeal, but there are layers underneath that, if that makes sense.
Thank you. We would agree with that position. It is a merits-based appeal, subject to, I suppose, you saying stepping into the shoes of SEPA. If you were to make an alternative decision, I would just ask you to recognise, obviously, as the regulator here and the expertise within the regulator, that there might be some elements of those that you couldn't substitute your own decision in, given the technical nature of this process that has reached these limits.
Well, it's actually part of that in mind. I'm thinking about this. I'm trying not to reach ahead into evidence that we're yet to hear, but I am conscious, because of the nature of SEPA as being both a party in this appeal and a regulator, and in one sense some of the guidance and some of the framework is a SEPA framework that SEPA also themselves apply, and so there's a question in my mind of ensuring a fairness in and equality of arms, I suppose, in that sense of looking at achieving a fairness in those circumstances. It's possible, I suppose, I could find myself in a position, I hope I'm not, but not in this context, but it has happened to me in other circumstances where for reasons that are entirely understandable, I could find a situation where I have competing evidence, and it's very, very difficult for me to make an assessment of which I prefer without having a technical background. And if parties are able to help me get to that point through their own expertise, then that can be reconciled. But I have had circumstances where parties, again for reasons particular to the appeals, have not really been willing to engage with me in the process of saying, no, if one side isn't right and the other side isn't quite right, what about the middle ground? And parties have said, well, actually, we're not going to address you on that. So part of my concern is, if I'm in that situation, what do I do there? I'll maybe say nothing. I don't think I need to expand on this before, because that's hypothesising on a situation that I've no reason to believe will arise in this particular case. But that's one of the reasons why I'm just I want to be reasonably clear from the outset, and you have been both very clear as to what you think the nature of my role is and how I should go about this exercise. But the first
I wonder if I can perhaps, well, hopefully allay any concerns you have, sir, in that regard. Obviously, this session, and indeed that in March, should, one would hope, provide you with enough technical information to come to a view on the facts. And in my submissions, eventually when they're made, I will certainly be inviting you, sir, to get off the fence, as it were, one way or t'other, and the appellant will be making its position clear once all the evidence heard, and inviting you to come to a view on those facts.
No, I was just going to add also that it will come to, well, closing submission and authorities as well, in terms of case law and looking at the expertise of the regulator, and I will make points on that in closing submissions.
And the difference that we'll hear about the views and the perspectives of what's actually happening on the ground. And so I'll be looking to SEPA to provide evidence as to why they think and how they can justify Table 13, but I'll also be exploring with with the appellant's witnesses questions about whether they accept that there is an issue, and if so, whether different levels within Table 13 could achieve the desirable environmental outcomes that could protect the environment sufficiently. And it's that I would really be looking to experts to be assisting me on. So that's helpful from that perspective. Right, okay, thank you. I had a couple of questions, just generally by way of background, just so I'm clear as to the statutory and factual background in the circumstances of the matters before me, and so I'm taking it that, I think as we said already, the apart from Table 13, the appeal is only in relation to that. I'm assuming that the description of the site in the most recent variation, the April 25 variation, is accepted, and there's a common understanding of the authorised activities. Those are not matters of dispute. I think you said already. The other conditions are accepted. Table 12 is accepted, and this is a complete I think it's a complete substitution of the previous permit that was in place. I was curious as to why the 2022 variation was lodged, but I'm presuming that's because what it substitutes is the 2022 variation.
So I can come in if you want. Obviously, it was the appellants that lodged both versions, but yes, our 2025 variation does replace the entire permit effectively.
So it was perhaps overkill on the part of the appellant, but it was just to provide a picture of the variations. A line could have been drawn perhaps closer to 25 than it was, but equally one could have gone back to the original permit and provided all the iterations.
It was overkill, but not overkill, because I say you could have provided about 10 variations or whatever. So I'm grateful that there was that was limited to that extent. Also, in terms of the background, my understanding is that the permit was originally granted under the first manifestation of PPC back in 2002, and it was continued. And my reading of the regulations, I didn't find it particularly clear, is that this site now becomes a landfill site of non-hazardous activities under what became the 2012 regulations. So this is a landfill permit.
Yes, it was
non-hazardous.
Initially issued, was it 2006? Back under the previous PPC regulations, which then when they changed to 2012 ones, it deemed across, it transferred across in those, and then
as a landfill permit.
Yes, it became that is the main activity under the permit, but there are other activities on the permit, as this appeal is dealing with the waste treatment activity.
And in similar vein from the appellants, I saw that the original licence was granted to a company called WRG. I wasn't sure if that was a transfer to FCC or whether it was a kind of rebranding of FCC at that point.
I'll ask Mr. Martin to address that.
You'll know the answer.
FCC is the parent company of WRG. It's a parent company.
The parent company. Okay, that's fine. Thank you. In kind of similar vein, I did notice when I was reading through some of the legislation under PPC, is there does seem to have been some legislative change even in the course of this appeal that taken place by way of the Environmental Authorisation Scotland Amendment Regulations of 2025, and that seems to have revoked PPC and the car regulations from a date in November. Now this appeal obviously was taken before that amendment took place, but I was just wondering, particularly from the SEPA point of view, if you could give me the kind of relevant references, not necessarily now, but the place at which that continuity continues to apply, both in terms of the authorisation to operate, but also in terms of my assumption that the appeal will, because it was taken before the amendments took effect, that the appeal proceeds under the regulations as they then stood. There are some continuity provisions I'd noted Schedule 23, paragraph 25 of the environmental authorisation regulations. But if you have any kind of confirmation, just so I can be clear, that I can happily continue to look at PPC and car as they then stood.
Yes, I can confirm that there are transitional provisions in the 2025 amendment regulations, which brought PPC and car, as you say, within the Environmental Authorisation Scotland Regulations 2018. The transitional provisions are in, as I say, the 2025 amendment regulations, and that effectively deems this permit across, but because this appeal was brought before that date, it continues under PPC.
But it's not been determined yet, so...
No.
So, as I say...
And just to add that in terms of the point about the onward appeal to the Sheriff Court, I think it's perhaps a bit unclear in the transitional provisions, but we would accept that in terms of reasonableness and allowing that onward right of appeal, that would exist as well.
But certainly if you give me at some point chapter and verse on which parts of the regulations keeps this appeal alive and applies the old regulations to that as you're looking at this just now. It did strike me that there is a read across will come shortly, perhaps even next, to the question of the application of the directions in 2014 and as amended in 2015, and I suppose one of my questions relates to the same point really, is the extent to which even if SEPA are right that the directions do apply in terms of the original decision-making process, I don't know if you can confirm whether the directions needed to be changed in consequence of those environmental authorisation regulations and whether they were or not. I'm not saying they needed to be, but I'm just thinking of the appellant's representation that the directions don't apply. Even if I were with you on the main point that there's just something I'm not sure about in terms of these overall statutory changes, as to whether the directions continue to apply. I take it they've not been changed, as far as you're aware.
So they have been updated in 2024, but that's because of changes at a European level that have then been enacted into the Scottish directions. So it's separate from ESER, but the ESER regulations will refer to the new 2024 directions, basically. So, so there's
not been updated as far as you know in relation to the changes that happened in November last year.
The ESER regulations does not change the Scottish directions themselves in terms of the content. The content within those directions is changed because of European changes and kind of cascading down into Scottish legislation. So some of the numbers have changed within the 2024 regulations, but not pertaining to these particular substances.
So some of the numbers have changed. What I'm thinking is on the appellant's argument that the direction don't apply at all. I'm just wondering, are there implications on that, with the fact that and the point the appellants make is that the reason why the directions don't apply is because of the definition of relevant enactments. And the argument that's put is that doesn't cover the basis on which SEPA have proceeded. And I'm only raising the question because, of course, the enactments have now in turn changed in November last year.
Obviously, we'll be dealing with this at the point at which the decision was made by SEPA, at which stage that was prior to these regimes being brought within the environmental authorisation regulations. But we can certainly double check that point if you have any concern in terms of that link going forward. When we deal with that agenda item, we'll show that clear legislative basis, how they do apply, and as I said, if we can certainly, we've not done it in our submissions to date because of the timing of the decision, but we can confirm that ongoing requirement certainly for you.
I mean, I'll maybe ask counsel for the appellants what she thinks on this particular issue. One of the reasons I raise it, I'm going to come in a second to the question about the application of the directions as such, but I noted that the environmental authorisations regulations were made under the Regulatory Reform Act of 2014, which is one of the relevant enactments in the for the purposes of the directions. Now, the same argument, of course, might flip the other way around, but this was after the event. This is not relevant to this appeal. But that's where the area I'm sort of thinking about just now.
Thank you, sir. You're right that is one of the relevant enactments that is referred to, in addition to CAR, which is the basis that we are doing under. So I would just need to double check whether that reference to CAR has been removed in the relevant enactments and relying on, as you say, the regulations made under the Regulatory Reform Act, or whether there has been substituted now with those regulations that have been made.
And the reason why that's important, this goes back to the discussions a few minutes ago, is what is my role? If I'm deciding this afresh, do I decide this afresh at the date Stephen made the original decision, or do I decide it afresh at the date of my decision? And at the date of my decision, on that argument, the directions are now brought in as a relevant enactment because they're made under the Regulatory Reform Act.
I think it would just be a different reference. It doesn't change the fact that they have a legal basis. So
your arguments have a legal basis anyway.
Yes.
The appellants don't agree with that.
So if you are in agreement with our argument and the legal basis for them at the time we made the decision, that will have not changed.
It won't matter
by this change.
And it would be surprising if it had been a change, I'm about to say, in the circumstances. But it was just when I noted that the 2025 regulations were made under regulatory reform, my head started to spin slightly.
I don't blame you.
on that particular issue. Now, you may need time to think about that particular point, but do you want to go on, either answer that just now, insofar as you want to, or more generally move on to the question about the application of the directions?
I will try and endeavour to address both, having just applied my wet towel. On the question of what legislation you, sir, are required to apply in determining this appeal, my submission is and will be in writing that, again, drawing analogies with planning appeals, you require to determine the appeal, because it's a merits-based appeal, on the law as it presents itself to you when you're making your decision. Likewise, if we're coming on to discuss policy documents which don't feature so much, but you would have to apply relevant policy at that time. Again, applying the wet towel, if I may, for a moment. As you are aware, it was argued in the appeal that the directions are not a relevant enactment. The regulations are not a relevant enactment to which the directions apply, and they do not apply to the setting of emission levels in the 2012 regulations. The position for the appellant may have somewhat shifted in regard to relevant enactment, but nonetheless the rest of the submission made in the appeal remains, namely that the directions do not apply to the setting of emission levels in the 2012 regulations. And without getting into a complicated legal argument, I can perhaps flag up where the arguments will run. And this is perhaps best dealt with by reference to the, sir, you have it, the joint note, which I'm not sure it's got a document number.
No,
And if I can direct you, sir, to section 3 of that.
Yes.
And red is the appellant's comments, blue are those for SEPA. And in section 3.1, parties are agreed that the directions apply only in relation to the, reading short, the exercise of SEPA's functions under, quote, the relevant enactments, only to surface water and groundwater within, etc., and only insofar as they're consistent with the directive and the groundwater directive. Then 3.2, it's set up, first of all, the directions require SEPA inter alia to A, assign a type or types to each river, etc., and B, imply environmental standards to each river, according where applicable to the assigned type or types in accordance with Schedule 2. And then the text continues, the directions are not relevant to the exercise of SEPA's functions in setting out ELVs, emission level values, in authorisations made under the 2012 regulations, and it's that with which SEPA disagree. Sir, you may immediately guess what the legal argument, or surmise what the legal argument is concerned, in that the directions are applicable to this question of assessing types for reading short rivers and applying environmental standards to those, and they have nothing to do with a function relative to the 2012 regulations, insofar as SEPA exercise car functions, or perhaps under the regulatory, or perhaps just under the regulations. Those have to be brought within the directions to be, sorry, take that out. Those functions are different to, well, the car functions are different to what may be required under the directions, and vice versa. And that's the argument. So yes, you may be able to shoehorn the directions, so you may be able to shoehorn car, or indeed the 2012 regulations, into the directions as a relevant enactment, but that only takes you so far. And you then have to address, well, I've got a relevant enactment here, but what functions are SEPA addressing, and how can I read across to the directions, if that makes sense? And I'm sorry, that's been very quickly done. It is a wet towel job, and clearly it will be the scope of perhaps more detailed submissions in writing, legal submissions, and but I think it's proper to flag up where the argument will run.
That's very helpful. And I certainly I've read the SEPA responses to that. I took the point that was which is within part 1. So I got that point. What I wasn't so sure about was both the point that was being made in relation to the nature of those the functions that are being read in, but also how PPC equates with car.
Thank you, sir. First of all, I was going to make the point about asking for clarification essentially as to what is the appellant's argument here. And in the original submissions from the appellant, it was based on the directions not car not being applying because of the relevant enactment point, but that argument appears to have changed in the course of the appeal through the joint note. I wasn't sure if they are still running the argument on relevant enactments. I'm happy to run through both, but the argument appears to be a slightly different argument now that came out from the joint note about their actual application only to effectively classification of water bodies for that purpose, which they're not. The directions have, would you like me to? I can. There is a very sort of detailed legislative basis here for this, and I'm happy to run through both. It was just whether you want me to deal with the relevant enactment argument as well. We've responded to that in detail in our submissions, so I perhaps don't need to go through that again, and can perhaps focus on the new argument, so to speak, because that hasn't been dealt with in our submissions. Okay. So essentially, from what I gather, is the argument of the appellant now is that the directions do not apply to setting discharge limits as we've done through table 13. I think in the joint note, just to refer to, yes, the joint note, the appellant had added point 3.6, which is that the classification and application of standards set out in the direction are not relevant to the setting of emission limit values in respect of the appellant's authorisation, to which we disagreed in the joint note, but we've not set out our full argument there, so I will try and do that now. So referring to the directions, they state that Schedule 2, Part C, which is where we've referred to, which brings the environmental quality standard limits in, their argument is that this sets out environmental standards in order to apply to relevant classified rivers the standards of high, good, moderate or poor for specific pollutants. And we are in agreement that the standards set out in Part C do apply for the classification of water bodies. Looking at the directions, you will see various references to once classified, and throughout there are references to that classification purpose. However, they do not only apply to classified water bodies. The standards apply to all of the water environment. If I could refer in particular to Article 1.3a of the directions. Sorry, I should give the reference number, isn't it? It's FCC document 20 and document 21, which is the amendment to the 2014 standards. So Article 1.3a provides that the directions apply in relation to the exercise of SEPA's functions under CAR as a relevant enactment.
Where did it say this? It's not the 13187.
So 1 subparagraph 3.a, these directions apply only in relation to the exercise of SEPA's functions under the relevant enactments, which, as we've discussed, the relevant enactments include CAR. And under B is the point that the appellant is referring to in terms of specific water bodies. So then if we look at Article also 3.2c, and that specifically provides that Article 3.1 applies to the exercise by SEPA of its functions pursuant to CAR as amended from time to time. So again, it's the reference to CAR. And if we look at back to 3.1, under point B, this requires us to apply environmental standards to each river, loch, transitional water and coastal water, or part thereof, according, and I emphasise the words, where applicable, to its assigned type or types, in accordance with Schedule 2, which sets out the environmental standards. So where we have a classified water body, the standards must be applied according to the assigned type. And so there will be different standards in the numerous tables that you find in the directions that will apply different limits, whether it's classified as high, good, moderate or poor. But there will not always be an assigned type or to parts of the water environment, as the classification process doesn't apply to all of the water environment, it only applies to the specified water bodies. And what we're saying is these directions, the environmental standards set out within them, apply to all of the water environment. So there's, I'll just come on to explain, there's essentially a dual purpose to the application of the directions. So they have wider application than just for the purposes of classification of water bodies. They also apply in controlling discharges to the water environment. And that has to be read with regard to SEPA's functions under CAR, which is the regulations which control these point source discharges to surface waters. Not our separate functions regarding classification of surface water bodies. So it's perhaps useful to trace these requirements back through the requirements of CAR and WUS, which is the Water Environment Water Scotland Act, which both are used to transpose the Water Framework Directive requirements. And I'd refer back to SEPA's original submission 2.3 for that. So the appellant has provided a copy of the Water Framework Directive, which is document FCC 28. And that, the Water Framework Directive is essentially, it is setting out the integrated approach to water management, including by regulating individual pollutants. The key requirements are set out in Article 4 of the Water Framework Directive. And that requires member states to use river basin management plans and programmes of measures to protect and, where necessary, restore water bodies in order to reach good status. That's both good chemical and good ecological status. So that overall aim applies to all of the water environment. Separately, there is a requirement under Article 4, if I can refer to the specific requirement that's under Article 4, 1.a subpoint 4, and that is to implement measures with the aim of progressively reducing pollution from priority substances and ceasing or phasing out emissions, discharges and losses of priority hazardous substances in line with these overall purposes under Article 1C of the Water Framework Directive. So SEPA's submission at point 2.5 sets out regarding the programme of measures, which is referred to in Article 11 of the Water Framework Directive. And that requires member states in their programmes of measures to include basic measures, which include for point source discharges, such as what were liable to cause pollution, as we're dealing with in this case, a requirement for prior regulation and measures to prevent or control the input of pollutants. So those can take the form of a prohibition on the entry of pollutants into water or a requirement for prior authorisation, which can also include general binding rules, as we have under CAR. But in each case, laying down and placing emission controls on the pollutants concerned. And then we've set out in our submission 2.6 a reference to the daughter directives that were introduced under the Water Framework Directive. So we have the Groundwater Directive, which we're not concerned with here, and the Environmental Quality Standards Directive, which is essentially what we're looking at for the application of the directions. So the Environmental Quality Standards Directive is essentially where the legal basis where it comes from in European law here. And that sets the environmental standards for surface water pollutants of the greatest concern across the EU, which we call priority substances. But member states can also supplement that list. And this all has been transposed prior to Brexit, of course. So we're dealing with a lengthy history of EU legislation in the field of water policy here, and a lengthy history of how that has been transposed in the UK and notably Scotland. But essentially under the Environmental Quality Standards Directive, member states must ensure that those EQS are met in order to achieve good chemical status overall for the water environment, not just classified water bodies. And SEPA, as we'll come on to explain later on in later agenda items, we are required to take account of these substances when assessing the risk to the water environment and controlling point source discharges.
So 31A, are you saying 31A only applies to classified water sources? Because 31A sets it must assign a type or types to each river, loch, traditional water or coastal water.
Yes.
Mm-hmm. So one of my questions here is has there been an assignment in relation to the rivers, loch and waters that are relevant to this site?
So there is the classification that occurs further downstream, but a significant difference from the sites. I think we said it's the Luggy water, there is the classification. So that is the water body that is classified, the nearest one to this site. But what we're saying is that essentially, yes, you've got that classification down at Luggy water, but separately you've got all of the water environment between there and the site, and including in the site, which is part of the water environment, for which we must control point source discharges. And in doing so, we have regard to the standards as set out in the directions in determining the thresholds for those discharges.
So there'll be a document somewhere that will have the Luggy water as being an assigned body of water for the purpose of 31A.
Yes.
When it says type or type.
Sorry,
Yeah,
I wonder,
the
it's,
Helen has submitted that.
it's FCC 26. Sorry to interrupt.
Shall I continue? Sorry. This is a lengthy description, and I'm happy, obviously, in our closing submissions or other to do a written document with all of this, since it's perhaps not fully covered in our submissions to date because we didn't have note of that argument at that stage. So if I refer to those SEPA submission 2.7, and that talks about how then the Water Framework Directive has been transposed in Scotland through the Water Environment and Water Services Scotland Act 2003. Again, apologies, I think in terms of the productions for this appeal, we've only got one section of that was because we didn't put in all the provisions, we weren't running this line, but that is where it's transposed. And that makes provision in section 20 for regulations to be made for controlled activities, which is where CAR comes in then. So under regulation 3.1 of CAR, if I can refer to then, that applies to activities liable to cause pollution of the water environment under A, and then specifically also bring your attention to G, which is any other activity which directly or indirectly has or is likely to have a significant adverse impact on the water environment. And that provides the mechanism by which the measures required under Article 11 of the Water Framework Directive are taken. So we have that requirement for prior authorisation under CAR, which applies to point source discharges and diffuse sources liable to cause pollution, and that can include measures to prevent or control the input of pollutants. And these therefore are concerned with compliance with the discharge limits and the environmental quality standards that are required under that directive and that are brought in through the directions in Scotland. And applying those environmental quality standards that may require treatment in order to meet those limits. And just to refer to the specific provision of CAR, so under Regulation 8.2 of CAR, SEPA must impose such conditions as it considers necessary or expedient for the purposes of protection of the water environment. Under A, so that's 8.2A. So just coming full circle then, in exercising these functions under CAR, Article 13A, as I mentioned, provides that the directions apply in relation to the exercise of SEPA's functions under CAR, and it's CAR that makes provision for measures for the protection of the water environment through regulation of controlled activities, and at no point does CAR cover that separate purpose of classification of water bodies, which is a separate application of the directions. And just to highlight as well that this dual purpose to the application of the directions, it's also evident through the different terms that are used. That again, we can trace back through the Water Framework Directive, WUS and CAR, in that classification applies to surface water bodies, and as defined in the Water Framework Directive, a body of surface water means a discrete and significant element of surface water, such as a lake, a reservoir, a stream, river or canal, part of a stream, river or canal, transitional water or a stretch of coastal water. So that's a discrete part of the water environment to which classification applies. And the other relevant definition in the Water Framework Directive is surface water status, which is the general expression of the status of a body of surface water determined by the poorer of its ecological status and its chemical status. So classification only applies to bodies of surface water, whereas the requirements under CAR applies to the whole of the water environment in terms of controlling point source discharges. And that comes from the definition of surface water.
That's the definition of surface water, not the definition of surface water status.
No. So we'll come, I think, on a separate agenda item, we talk about the definition of the water environment, and we can show the link through there as well. But it was just to highlight the difference between surface water and surface water bodies to which classification applies. Perhaps just to conclude on this part, so the thresholds, the directions essentially set out limits for all of the different substances and parameters covered there, and these essentially are setting thresholds both for the purposes of classification, but also for in terms of how we look at how we control discharges and reducing discharges to the water environment. And I'll just finally refer to also Policy 61, which is SEPA Document 4. And if draw your attention to page 3, and this refers to this approach of controlling discharges to surface water to ensure that they don't compromise compliance with environmental quality standards, and this separate purpose of compliance with the EQS to determine the chemical status of water bodies for classification purposes. Policy 61 also has a appendix that sets out the legislative basis, but it is referring to older directives. It hasn't been updated at this stage, but it gives you that framework certainly of where this comes from. As I said, I'm happy to do a written submission and follow up to this hearing, setting that all out. It's quite a complex interplay.
The whole thing's a complex
Yeah,
interplay.
particularly with also when you combine that with the interaction between PPC and car as well. So it's not an easy area to understand.
I don't know if the accountants want to say something at this stage. Just 5 minutes out, or whether you're happy to comment on what you've heard. I suspect it will require further submissions.
Sir, yes, thank you. And I don't even think 5 minutes would suffice.
That's
I would prefer, and as I think I've flagged up, or was flagged up in various items of correspondence between the DPA and those instructing me, these matters are complicated legal matters, and I think would merit, echoing what Ms Armstrong had to say, would merit a written submission. Rather than my lord taking a note, and it does require a fair amount of tap dancing around various regulations. So I would rather not respond in detail, if that's acceptable.
No, that's absolutely fine. That makes sense. One of the things about my role in all of this is, if I'm with the appellants as to the suggestion that the directions don't apply, one of the questions in my mind is whether the appellant's position is that SEPA's mistaken apprehension that they do apply, whether that has the effect of entirely compromising their decision-making process in this appeal, or that's in the case has led to this appeal, or to what extent could I take into account evidence and reach a view that these requirements in Table 13 are still required, even if you disregard the directions, given that I'm a decision maker afresh. This goes back to, and you now better understand why I'm asking these questions about what my role is. Is it possible to reach a proper determination on what the standards of restriction on emissions are if you discount the directions entirely? And could I, for example, agree with what the appellants say, that the directions do not apply, but still come to a view that levels X, Y or Z within Table 13 are the right levels? So I suppose it's the consequences of your submission, I suppose, if indeed it is right that the directions don't apply for the reasons you say.
Sorry. I wonder if I might direct you to Regulation 25, and that's SEPA. Indeed, it's SEPA document 16 little b, but it's also set out in paragraph 10 of the. And the reason I'm directing you, sir, to Regulation 25 is effectively this is, if you are stepping into the shoes of SEPA, as I submit you are, making the decision, this is the framework in which you are entitled to come to a view. And as I understand, first of all, reading short, 28.2, a permit must include emission limit values for polluting substances, reading short. And no issue is taken, I should add, that the 3 chemicals to which exception is taken in this appeal are polluting substances. Then there's reference subparagraph 6 to BAT conclusions.
Yes.
And then in subparagraph 7, an emission limit value under paragraph 6 may be set at a different value in terms of value, etc., provided that SEPA assesses various things. 8, where any BAT conclusions describe best available techniques but do not contain an emission value must, and it's then set out what it must do. And then leaving aside the niceties of BAT, and again, my lord, sir, you'll hear evidence about that, but as I understand it, SEPA is relying, and indeed you, sir, may rely upon subparagraph 9. SEPA may set stricter permit conditions than those achievable by the use of the best available techniques as described in BAT conclusions. As I understand it, according to their response to the appeal, SEPA do not rely on subparagraph 11, which is a requirement that SEPA must include additional measures, etc., where an EQS requires stricter conditions. As I understand it, SEPA put themselves into the general discretion area of decision making, although they say that by reference to the directions, but they don't rely upon subparagraph 11. And I would submit, sir, that it be open to you, having regard to what limits may be set, it would be open to you to set a level which you consider would be, to quote the words of Carr, necessary or expedient to protect the environment.
If I could just come back on a few points. So I suppose your first point about whether it would be possible for you to reach a determination on what limits should apply without applying the directions, to make the point that that would not only affect the outcome of this appeal, that would affect the entire decision-making process of SEPA and how we apply discharge limits to the water environment. Essentially, every car authorisation that we have that is discharging a point source discharge to the water environment, the limits are based on the application of the directions. Yeah. So to clarify that point, on the point about if you were to step into our shoes and applying the stricter conditions under PPC Regulation 25, again, the basis for applying these limits has come back to we are applying them under CAR, and the PPC permit in this case is taking the place of the CAR authorisation, which is the interaction between these two regimes, and so it's not under the specific provisions of Regulation 25.
25 11.
No.
Or not under 25 at all?
No, it's not under Regulation 2511, because we've not, as we'll come on to when we discuss the interaction with BAT, we've not done this as part of a BAT review of the conditions of the permit. We are applying this in our duties under CAR, and the PPC permit here is taking the place of the CAR authorisation. It's effectively forming the CAR authorisation for that point source discharge.
I also have a question about Regulation 55.
So I think we've dealt with Regulation 25.2 in our submissions, in that we said that this really is the basis for putting in a limit deciding what pollutants we cover for PPC. You've got the ones listed in Schedule 5, and if they're not in Schedule 5, you can put in other polluting substances if they're in significant quantities. Given that the appellant has not appealed against Table 12 and the introduction of these polluting substances, and they've accepted that they are polluting substances, I don't think we need to go into that point, if you would agree.
I just want to look at the implications that are that flow from the fact that there's an acceptance to paragraph. The Table 12 applies, even the Table 13 doesn't. I think that's something I'd like to explore.
Yeah, my understanding is it is accepted that there needs to be limits for these substances, but it's a question of what those limits are.
I know that I mean, there's various sort of big issues that come to mind from the appellant's perspective. That's definitely one of them. pretty quickly on to section 3 actually, but we'll maybe take a break till 12. Thank you. closer to people for that. So yeah, as I said already, I think that we've probably had the discussion that was necessary in relation to items 2.4 and 2.5 mentioned already, issues of fact, identification of matter, as agree, which may be updated over time. And I think we've covered in other parts of discussion issues in relation to the ongoing compliance with the permit. Section 3, I've headed up as decision making by SEPA, and again I think we've discussed a little bit of the topics in relation to this already. So you want to say something about?
So perhaps could I come in terms of point 2.5? Perhaps we haven't fully dealt with that. I think the points SEPA would like to make in terms of the consequences of it being quashed is that, as we've put in our submissions, that would have the effect of quashing the entire notice. And I know you've very much focused on the appellant's continued compliance at the moment, but it's just to set out, I suppose, the changes between VN-03 and VN-02, the permit that existed before, is that there are other conditions in the previous version, which would revert to if the notice was quashed in its entirety, that are not subject to appeal, and they are important changes as well, and the appellant has been compliant with them, but SEPA would be concerned with, I suppose, reverting to that former version of the permit for a number of reasons. I think as set out in, there's changes to, as we said, the table 12, which now includes the limits for the 3 parameters that we're dealing with in this appeal, which were not previously covered in the permit. And there's also increased monitoring requirements. So if we were to again revert to that previous version of the permit, we would have reduced monitoring requirements, which we would certainly be concerned with due to the impacts on the water environment and need to monitor these discharges. For example, I think there was general monitoring of metals before, but not specifically on these pollutants that we are concerned with now. There's also the issue of sector consistency, which is a focus for SEPA and was part of the reason for the variation being issued here, was that we were moving to the new non-hazardous landfill template, yes. And we were doing these variations on a sector basis. So if this variation was quashed and we were to revert to the previous version, we would have inconsistency across the sector in terms of this being then the only non-hazardous landfill in Scotland that was then on the previous conditions. I don't know if perhaps Stephen or Richard want to add anything just in terms of the conditions under the previous permit, because while we've had that reassurance that the appellant is complying with all of the conditions, our position is that those conditions did not offer adequate protection for the water environment. So I'll just add.
Yeah, I'm happy to come in there. Yeah, so if we were to revert back to the previous permit conditions, we would essentially be reverting back to 3 contaminants that would be getting controlled through the discharge with a limit. So the reactive phosphorus, nickel and chromium would be removed from any kind of consent limit from the permit. There would also be, as Josephine's touched on, there would be a reduction in the frequency of monitoring of these contaminants of concern. It would revert back to, I believe, 6 monthly in the downstream surface water monitoring point. And also in general terms, there would be inconsistencies in how we regulate the site in terms of the requirements for engineering on site, things like capping, CQA type requirements would revert back to the older style of conditions rather than the reviewed conditions.
I mean, I hadn't really taken it to be the case that the appellants were disputing the majority of things that were in the permit. And what you're saying is, if you like, if the permit was quashed and the 2022 permit was to revive, there'd be a gap in terms of regulation. The reason why I thought we'd kind of covered this already, and I was reasonably satisfied, is if at the end of the day the view was reached that table 13 should be quashed, but that the whole permit would fall in consequence of that, because of this issue about powers of modification and powers of variation. I was conscious that the obligations under table 13 don't apply as yet, and only have an obligation that apply from the end of March next year. And so it had struck me that there was some scope then in those circumstances for effectively allowing the appeal, but having that appeal allowed from a kind of specified date effectively, that would then allow SEPA to, if you like, to reimpose effectively all parts of the permit that are not disputed. So there will be a time period, and that with the fact that table 13 only has a real resonance from a date that it's set to be applied from, and if the decision relieves the appellants from the obligation to then work towards that gives a time period in which that can be done. But whether SEPA would continue to have concerns, what I would say is that I don't think that concerns in that regard are a reason in themselves not to allow the appeal, if you see what I mean. I think that would be going too far. But that was kind of what I was thinking.
Thank you, sir. It was just to make the point about those consequences of if it was quashed and we reverted to the previous version, just to make clear, and also just to make clear that while absolutely the appellant has the right to bring this appeal, the bringing of the appeal doesn't suspend the operation of the condition that is being appealed just now in table 13. But if the decision was to quash notice, and we were then required to do a subsequent variation, bringing in all those other changes that we did do through that, that again opens up a right of appeal to the appellant. So,
Sir, I don't know if it assists or not, but if you were minded to quash the variation, no doubt hamstrung by the terms of the regulation, the appellant would have no difficulty in providing an undertaking, or indeed entering into some form of formal agreement in relation to the other parts of the variation. I do not foresee a difficulty. It's probably best not to do the drafting this morning, but I can give a general indication that the appellant is more than willing to work with SEPA in relation to the other conditions.
we thank you for that reassurance. I suppose just to make the point again, though, that ultimately we would have to do a further variation, which, even with an undertaking by the appellant, doesn't override their statutory rights of appeal that would exist.
Indeed, absolutely, that would obviously still be the case. But there's insofar as we can tell the future at this stage, if what was done was the simple reimposition of the permit, omitting table 13, then in terms of what's been suggested so far, that doesn't look as though that's likely to be something that the appeal right will be exercised in relation to. But it clearly could. I mean, that solution may well be a sensible way of dealing with matters, because it may end up just being a timings issue rather than anything else. And an undertaking, I can see the point that an undertaking in a long-term, relying on an undertaking on a long-term basis would cause some anxiety to a regulatory body, but that's not what's been suggested, as I understand it. Okay, well, thank you for that. Unless there was anything else, I was going to go on to just invite parties to speak on the respective issues in relation to decision making. To speak a little bit on item 3.1, if there is anything that anyone wants to say over and above what's been said already about looking at the overall duties, and I'm interested in the kind of the purpose of interpretation, purpose of approach to SEPA's duties, bearing in mind the roots of all of this in EU law, which no longer applies, of course. But the framework nevertheless has continued in the way that's been described, and essentially as I would interpret the approach, the only effective difference is there's now no longer a European Commission to complain to if issues arise. But the general approach to that, and of course part of all of that is the nature of looking at EU law was very much encouraging a purpose of interpretation of obligations for that. So I'm really just interested in both parts. I'll start with SEPA views generally, and I know that the appellants have views about some overarching duties, and part of their complaint and objection in this case, I won't put words in their mouths, but that SEPA have lost sight of that bigger picture in terms of looking at the kind of focus on this site, and actually there are drawbacks, including some transportation issues of having to take things to Grangemouth, for example. But I'll let the appellants speak for themselves. But start with SEPA.
If I could just, so draw attention first, I suppose, to the overarching duties under PPC, since that is the regulations that we're dealing with. As the appellant has highlighted, we've got overall aims under that. In particular, the overall aim under PPC is to ensure a high level of protection of the environment taken as a whole by measures that are designed to prevent, or where that is not practical, to reduce emissions to air, water and land. So that in terms of what we've done here in imposing limits for these polluting substances into the water environment, that is very much in keeping with our overarching duties under PPC, which is if we can't prevent their discharge, which we're by no means saying that this landfill cannot discharge leachate here, that would essentially stop operations. We must reduce them to the minimum possible. And that's where the requirements for treatment come in, and we'll talk more about that when we talk about the interaction with BAT as well. But in terms of just to highlight that overall aim, so I think we're very much aligned with those overall aims of PPC in our actions. Under CAR, we've got, as I've referred to before, the duty under Regulation 8.2, which is a duty on SEPA to impose such conditions as it considers necessary or expedient for the purposes of protection of the water environment. And again, as we'll address further on in the agenda, the protection of the water environment is very much our justification for imposing these limits, as we've considered necessary to protect the water environment here. As we've set out in our submissions before as well, Schedule 10, paragraph 9 of CAR as well sets out our duty to review authorisations to apply the requirements of CAR, which is where our duty here in reviewing the permit to comply with CAR came in. And we have a duty to take such steps to ensure that this authorisation complies with the requirements of CAR, again referring back to our duty to protect the water environment. So our position is that until these limits in Table 13 do come into effect, the PPC permit in its current iteration does not comply with the requirements of CAR, as does not adequately protect the water environment from this discharge of treated leachate. So you mentioned the previous position prior to Brexit of, obviously we had the European Commission as checking compliance with all our directive requirements. We now have Environmental Standards Scotland, who is really looking at how we apply legislation and whether we are correctly applying legislation. So at the moment we would say that this permit doesn't ensure that adequate protection of the water environment. So we could very much well be criticised for not applying the requirements of CAR here. And again, I'll highlight when we come on to talk about that interaction with BAT, but just to highlight as well that the Water Framework Directive and Article 10 of that also talks about this combined approach, and with PPC they're very much geared towards that holistic view of the environment, all the different medium. So even though we had previous regimes, water, waste, PPC brings those together and that is reflected in Article 10 of the Water Framework Directive, which is showing that interaction with PPC and that need to apply stricter controls again where there are stricter limits under EQS. And the final overarching duty that SEPA has we have lots of different duties, and it's very much a balancing act between duties, but the one to highlight and that has been raised by the appellants and by ourselves in our submissions is with regard to our climate change duties. And again, this will be addressed in later parts of the agenda, but SEPA has a duty to act in the best way to mitigate and adapt to climate change in accordance with its climate change duties. I'd refer you to our submissions 4.4.2. So these are set out under Part 4 of the Climate Change Scotland Act 2009, and that is to act in ways that are best calculated to contribute to the delivery of emissions reductions targets, in particular Scotland's target of net zero greenhouse gas emissions by 2045, to act in the best way calculated to help deliver any statutory climate change adaptation programme, and to act in the way it considers most sustainable. And these duties require not only in terms of SEPA's internal actions, our own carbon emission savings, but it also requires us to meet these objectives through the delivery of our functions under the various regulations. So that means we must consider climate change in our decision making and developing policies and strategies, but also when making regulatory decisions. But to point out that this is very much a balancing duty in the whole with our other duties. And here we've got three parts to the climate change duty, and we should consider all three parts of these with equal consideration. But it's up to SEPA in terms of which duties we apply to determine the degree to which we apply them, and ultimately what decision we take on that. So while the effect on emissions should be a key consideration in any decision, it's not going to be determinative. It's likely that, you know, most sites such as this one that we regulate, there will be emissions, there will be power requirements, but that doesn't mean we don't comply with other of our duties which are set out under our various regulatory functions. And I think emphasising in particular that third duty under our climate change duties, that is also set out in SEPA's statutory purpose in terms of sustainable development. So it's not a new thing to us. We've had that requirement for some time, but there are essential two conditions to sustainable development, and that key to that is living within environmental limits. So where we have clear duties here to apply environmental limits to protect the water environment, the fact that there may be increased power requirements, increased emissions from the treatment in order to do that, doesn't mean that we would disapply those environmental limits.
What I'm mulling over when you're saying that, it goes back, and I apologise again, going back to the issue of the nature of factors that I take into account, and obviously I need to make my own view on the detail of what's before me. But in terms of these overarching duties, I suppose one of the questions I'll address to both parties is, what weight do I play when I'm making a decision afresh to how the overarching duties on SEPA are to play into that process?
Well,
It's a slightly rhetorical question, I appreciate, but I need to work it out myself. But I'm interested in the views of parties on the approach I should take with those sorts of questions in mind.
I suppose in terms of the weight you give to climate change duties, the reporter and the Scottish ministers will also be subject to those duties as well separately. So in terms of weighting, as I've said, this is very much a balancing act. Climate change duties have regard to and act in the best way, so we need to weigh that up on a case-by-case basis on a decision. So for how you approach that weighting, I'm not sure I can answer that one yet.
I mean, it's fair. I don't think there is one right answer to that question.
But I think I just wanted to, in terms of that sustainability element of it, the third one, and the one that it's part of our statutory purpose. So, you know, we have a duty, and in terms of car, that is a must. We must apply those limits in order to protect it. Whereas balancing that against other ones, which are more framed in a have regard to, that's where your balancing equation comes in, isn't it?
I mean, maybe the issue doesn't arise because of that question is that I need to make an assessment as to whether compliance with CAR requires this. And it may well be that I don't have to then turn to the question as to whether there's a sort of a wider objective, a purpose of objective to be.
Yeah, and I think perhaps
secured.
when we come on to later agenda items, we can assist you in that respect in terms of, you know, the arguments over the wider climate change duties as well have come in respect of the particular treatment option here. But as you'll have seen from the permit condition, you know, we're not specifying a specific treatment option here. That is very much up to the appellant, and the appellant will obviously have their own approach to sustainability and carbon reduction and carbon accounting, that they will look at these different factors. We can't step in and tell them which one to.
I'm very conscious of that, and I do want later on to explore that a little bit. That there has been suggestions made. I mean, one of the issues from the appellants that I think is really important to this is that their position is that the steps that are required to be taken to comply with this are just disproportionate or uneconomic or too much. But not only that general proposition that this would cost them too much and might even have wider implications for parallel operators, but also the extent to which other alternatives have been looked at. So I need to explore that, I think. But I think the bottom line remains is that if the evidence points to the levels that are being imposed, then that's a question before me. But if that's established that those levels need to be met, it must be within the discretion and the power of the appellants to decide how best to achieve that.
Mm-hmm. Absolutely, I would agree with that.
Okay, right.
Thank you, sir. Easy point first, if I may. Climate change responsibilities, duties. We're all in this room aware of the policy, very heavy policy support from Scottish Government relative to climate change. But I would agree with SEPA to this effect that ultimately it'll be a matter for you, sir, to weigh that up. But in my submission, and it will be my submission in writing as well, you have to have regard to the climate change duties. As I say, we know there's very strong policy support from the Scottish Government relative to that. My Lord, I wonder if I may introduce this general topic of the agenda by referencing, and the easiest way to look at it is in SEPA's response, but referencing one of their guidance documents, which has been given the number SEPA 1, but I actually think it's SEPA 2, but the easiest way to find it is in 4.2.20 of the response.
Oh, yes.
And the relevant paragraph is quoted: in setting permit conditions, SEPA must consider whether any EU EQS is being or may be breached. If so, SEPA will have to set ELVs. Now, just pausing there, as we know that is SEPA's contention, and the guidance then provides they will have to set ELVs based on how much the installation is responsible for the breach and the likelihood of remedial action elsewhere. This may require ELVs that are tighter than those required to implement BAT. Now, the point I make there is, it may be immediately appreciated, is again, this all goes back to the balancing. And two questions, it seems, to the appellant with respect have not been addressed by SEPA in setting ELVs, assuming that the EQS may be breached. They have not addressed how much the site is responsible for that breach, nor have they addressed, and this takes up the overarching weighing of interests, they have not assessed the likelihood of remedial action elsewhere. For example, some of the techniques which the appellant suggests might be appropriate. And this, of course, is all under the umbrella of the overarching aim of the PPC regime. And again, in this respect, if I could invite you, sir, to look to the appellant's response document in July last year, by way of a hopefully simple way into this. Paragraph 2, the appellant is of the view that SEPA is correct to observe in its response, and it quotes from that response, the main aim of the PPC regime is to achieve a high level of protection of the environment, taken as a whole, and I emphasise taken as a whole, by measures designed to prevent, or where that is not practicable, reduce emissions to air, water and land. PPC requires an integrated approach to the operation of the installation using BAT, rather than assessing individual emissions or unit operations in isolation. Within this overall aim, the PPC regime has a number of specific objectives, including that no significant pollution is caused, and to prevent or reduce emissions from installations by applying BAT. And again, no issue is taken with that broad statement of principle, but it all goes back into a weighing exercise of balancing, having regard to the overarching aim of the PPC regime, protection of the environment taken as a whole. And then, of course, we've already had the discussion about the Climate Change Scotland Act, and the SEPA has already made submissions this morning about that, echoing that which they say in their response to the appeal. The appellant's position is summarised in paragraph 4 of the response, if you, sir, still have it, to the effect that SEPA have failed to seek to achieve a high level of protection of the environment taken as a whole, and they've not acted in accordance with their duties to the best way to mitigate and adapt to climate change. And then there's reference to the correspondence. I know we'll come on to that, so I won't deal with that just now, simply to flag up the overarching submission on the part of the appellant, rooted in the overarching aim of the PPC regime. And that, again, is in the context, as paragraph 4 goes on to state, and I know we're coming on to this shortly, the water environment to which SEPA has had regard and pollution control of that has been, it is the appellant's contention, solely to the water environment of a small water body, that is the unnamed tributary of Cameron Burn, in isolation from the wider water environment and from the environment as a whole. And there's already been mentioned, I know we'll come on to discuss this in detail, but it might be useful just to flag this up. We've heard mention of Luggy water, and the appellant has lodged the relevant classification of Luggy water, which is about 6 kilometres downstream. The overall classification is good or moderate, whether one's looking at ecology or chemistry, I can't remember which way round. This may also, again, be explored further in the ecology evidence. I suspect it will be in 4th of March, but it will be the appellant's submission that insofar as the ecological status of Cameron Burn is concerned, that is not, or at least not significantly due to the emissions of these pollutants. And so far as the wider water environment is concerned, by which I mean 1 kilometre perhaps downstream, and that's why I was asking what source points were shown on these maps, but further documents do show this. There is little, if any, evidence of pollution or damage, adverse impact to the wider water environment. So yes, while one may be able to identify within a very short radius of the site of the installation chemicals which exceed the EQS, one then has to go on and ask, having regard to the overarching aim of PPC, whether it is necessary to set limits at that EQS level or based on that EQS, or whether a more proportionate response would be as the appellant would have it, namely table 12 or something equivalent to that, which would have achieve the overarching aim of the PPC regime to protect the environment taken as a whole. In this case, the wider water environment, by which I mean a relatively short radius and the ecology within that water environment.
One of the matters that's raised is the question as to whether the works that are suggested, steps that are suggested by SEPA, would actually, when balanced in the round, have other adverse environmental impacts, in particular, as I understood it, in relation to the transportation of waste, particularly to the wastewater treatment plant at Greengairs.
Indeed, that's the contention of the appellant.
Yeah.
And I say, I know we're coming on to discuss this later. I think chapter 4 of the agenda. But if you wish to explore that now, I'm obviously happy to deal with that.
Probably stick with the line of the agenda, just like that point. Mentioning it and thinking about it, I'm conscious that when that representation is made, it's useful also to bear in mind that when I went on site, there was an indication that the site here, as I understand it, is one of a number that's operated by the appellants that draw together.
Yep.
It's a centralised place that draws together.
Sir, if it assists, it might help to hear from Mr. Martin, who'll know far more about how the site operates within the wider orbit of the FCC business.
It's what we call a hub site, so therefore we have a central facility with spokes which are the other landfill sites. The other landfill sites themselves do not produce enough leachate or enough frequent leachate to justify a treatment plant on the site, therefore you centralise and bring it to that site. Hub and spoke.
And how many other sites?
There are 4 sites feeding into Greengairs.
If I could perhaps come back just on some of the points raised by the appellant there. So taking this reference to in the overall aims of PPC to the environment taken as a whole, it's worth clarifying. This very much again comes from the history of the development of PPC regulation and under the Industrial Emissions Directive in Europe, and the predecessor to that, the Industrial Pollution Prevention and Control, Integrated Pollution Prevention and Control Directive that predated the Industrial Emissions Directive. So this was the first directive that took that integrated approach covering multimedia, whereas previously we had emissions to air regulated, we had emissions to water, we had waste. IPPC brought them together in that integrated fashion for these large industrial installations across Europe, and that's where we have the reference to this high level of protection of the environment taken as a whole, because it is covering emissions to air, water and land. It's taking that integrated approach to the regulation of an installation, which it wasn't before. So it's not necessarily, I think, as has been put forward, that you're looking at this. Obviously, you're looking at how emissions from one part of the installation affects emissions from the other, and limits you put on that. But taken as a whole is not looking at this wider, at some distance part of the environment. You're still regulating the emissions from that installation at the point that it leaves the installation, and that is the key point to make. So to say that this allows that reference to taken as a whole allows a level of pollution at the point it leaves the installation, just because then a long distance from the site it doesn't have the same impact, is the wrong approach, and is not what is intended under the legislation here. And that is also reflected as I've said in the history of how water legislation under CAR and deriving from the water framework works, it's about point source discharges, and it's looking at that impact at the point that we assess the impact on the water environment. And we'll come on to that in later items of the agenda as well. But it's just to perhaps clarify around that reference to taken as a whole. And if I could come back also just on the reference to our Part A guidance, which is referred to in our submission at 4.2.20, SEPA document 1. So SEPA must oh right,
Yes.
apologies, SEPA 2. Yes, SEPA 2, apologies. So the reference here to setting emission limit values based on how much the installation is responsible for the breach, and that is very much looking at the point that it discharges. Are there other upstream impacts that are obviously already in that water course that are responsible for that breach? So we wouldn't be setting a limit if this was coming from somewhere upstream of the site's discharge. Obviously we have to consider what is responsible for the points at the point that we assess it. And we have done that in this case, and we do that in every case where we're setting limits. So I would, disagree with the contention that we haven't based it on how much the installation is responsible for the breach. And we'll come on to that in the agenda item that's looking at alternative sources.
Yes, and that's what I was looking at just now. Is that, oh yes, that's that good one. So come to that short there.
Yeah. And then the second part in that same sentence, and the likelihood of remedial action elsewhere. Obviously, if there was another source at the point that it's entering, at the point that we're assessing it, we would then be looking at what requirements are we placing on that, what action is being taken to address that other source. But again, upstream. So in both those regards, we have still applied what we said in our Part A guidance here in setting ELVs.
Lodged the site management plan of August 2022. I think that was it was largely because it was I think it was referred to by the appellants. I mean, to a certain extent, the agenda is slightly out of order in the sense that one of the questions I wanted to ask about the site management plan relates to the discussions about the status of the river sources going back to 2019. And maybe I'll just plant just now a question that we'll address later as to why the development of a site management plan of August 2022 for whatever reason appears to have been unsuccessful in reconciling the differences between the parties as to the status of the rivers and water sources concerned. So there's I think we'll come back to a bit later on. More generally on the site management plan, I'm not sure I want to look at necessarily the detail of it, but I wonder whether the discussions around a site management plan are seen as a means by which discussion can be ongoing between the regulator and the permit holder to try to kind of secure a common understanding as to what's needed. And the point, I guess, is that it's clearly, even by August 2022, that wasn't something that had succeeded. in reconciling the position of the regulators and the licence holders. So I suppose my question is about what's the kind of purpose of a site management plan? How does it get developed? How then can those who need to be regulated, those who are doing the regulation, how can they use a site management plan, and was it effectively used to try to identify what was needed to be done, and through that site management plan giving effect to that?
But perhaps bring Stephen in just to explain the purpose and the development of this site management plan.
Yes, so I'll come into that one. Yeah, so the site management plan of August 2022 was really developed based on the permit at that time and the conditions within the permit at that time. I don't think at that stage of the conversation there was agreement that there was impacts and different things, so the development of that management plan wasn't the aim of that wasn't to address the issues that had been identified in 2019-2020 with the view to the off-site impact. The site management plan is an operator document. It's for the operator to maintain and update as the site develops and different activities get added into the permit and various things. So yes, and again that would have been pre the SEPA initiated variation, yes, and pre the template that was developed. And round about that time, this is not to go into too much detail, but the landfill regulation team that we are part of was set up by SEPA in January 2022. So the first year of that team, we did a audit assessment of these operational non-haz sites, which then led into developing a new template, and further on the back of that there was a specific landfill management plan guidance, which I think was published in 2023, is that right, Richard? So as much as this management plan was the one before the permit review, it was probably outdated at the point of the permit review, and there was an upgrade condition put in the permit, or there would have been an upgrade condition put in the permit for a new management plan in line with the guidance that was published in 2023.
Would there be a typical frequency for how long a management plan would subsist for, or is that just too site specific to?
Yeah, it's probably a bit site specific. There would have been in some of the older iterations of the permit, it would have required maybe a 2-year cycle, but for particularly for a site the size of Greengairs, they would routinely review their management plans. Within the year you could get multiple versions, and I should say the management plan, there could be 7 or 8 management plans within the site management plan, and they could all have different. So there's ones to control nuisance, there's ones to control engineering, and they can all be updated within that. Yeah.
And you say, as with my understanding, it's an operator-led plan, and Mr. Martin can tell us a little bit about the development of that, since I think you were probably around at that time. I suppose one of my questions on an operator-led plan in those circumstances, and hearing that at that point there was recognised to be a disagreement between the parties about some of these factual circumstances not yet resolved, even as things stand just now. One of my questions, I guess, is if you're looking at kind of sampling points in order to get a proper and full and accurate idea of, for example, how much of these pollutants are coming from this site, is a site management plan a tool by which you could agree, or the appellants propose, sampling points to give an accurate indication that would then inform decision making after that?
Yeah, so yes, it would allow, the intention of a management plan is it allows the operator to control and manage their own operations. However, where there is disagreement, a permit condition will always take precedent over a management plan. So if we couldn't gain agreement with an operator through a management plan process, then we could or would set permit conditions and would always default to what the permit conditions required.
So the permit would prevail, but there's no suggestion, I don't think, that there was a plan in this case, such as it was in 2022. It's not been suggested there was any disagreement.
Yeah, it could definitely be used as a vehicle. I think just to go back to that time, August 2022, I don't think the conversation was as developed to the point that we could have set. The review of the Colmert report, for example, was one of the key points of identifying the contaminants of concern, and at that time, August 2022, I don't think we would have been ourselves or the operator in a position to develop that management plan in a way that could have controlled or regulated these contaminants.
I mean, maybe this is drifting a little bit too much into the evidence we're about to hear, but I'm just interested as to why, if SEPA had those concerns at that point, and particularly the data of August 2022, those concerns still didn't inhibit the ability, initiated by FCC, to do a site management plan that apparently was something that SEPA were satisfied with.
I think that comes back to that we couldn't require the operators to put that in a management plan. That would be for the operator to develop and design a management plan. We would have to do it, as Richard's touched on, through a condition in the permit, and that's how we would enforce against it and require it.
No, I can see that for enforcement. I'm going to turn to Mr. Martin now, just to get your sense, if that's okay, to get of the sort of the purpose and use of it, of a site management plan, and whether that was something that was considered at that time as a means by which you might suggest sampling points.
Sir, I wonder if I might,
Of course,
before
absolutely.
Mr. Martin, just again frame this by referring you to an email chain which is FCC 46.
Oh, yes.
Dated 25th August 22,
Yeah.
but the first item in that chain is an email from Colmert, who were FCC's consultants, and their report is also in the bundle. But on 6 November 2020, they were seeking to engage with SEPA relative to that, and indeed there were various points used for testing, agreed as I understand it with SEPA, set out in the Colmert report. So it is important in my submission to bear in mind that FCC have sought at appropriate times to engage with SEPA. And again, when one looks to the correspondence leading up to the actual variation, in my submission one can see concerted efforts by FCC to engage with SEPA in a constructive manner. And I recollect, and no doubt if I'm wrong my recollection I'll be told, but I recollect in one of the responses from SEPA there is a comment to the effect that there's no requirement for SEPA to consult in coming to a variation. No doubt that's true, but that has to be seen against the background in my submission of FCC seeking to engage with SEPA. And I'll leave it over to Mr. Martin perhaps to deal with the more...
Trying to get those emails up just now.
Sorry.
I've got the reference, thank you. I can find those.
Yeah. The first chain is FCC 46 and the second is 47.
I've seen them come in the past few days. I know they were launched before, or referenced before.
That's probably a very long way of saying the same thing, which was until the permit draft was received, we were not expecting any new changes for emission limits. The discussions around the Colmert reports and the ecology reports had gone nowhere. The discussions had ended. So it was literally, we received the permit variation, it was, oh.
So is it okay, Far? Yeah, so I would just probably reference back to a site meeting was had by, I think, chemistry, ecology, water resources unit from SEPA met in the head office at Greengairs. So and there was extensive correspondence and dialogue for 12 to 18 months, I would say, in the lead up to issuing the permit, as well as obviously the draft consultation that was sent out. So I would suggest that SEPA engaged in extensive dialogue. Yeah.
More about the site management plan more generally, since it was there documented. I give that general opportunity rather than an invitation to speak. If you don't feel you want to add anything to it, but it was in the case. So.
It's more a case of that's about how you operate the site to deal with the permit as you've seen. And the permit then changed, therefore it has to change with the permit.
Okay. I'm hesitating a little bit. I'm thinking about moving on to item 3.3, which is the interrelationship between the back conclusions and the obligations that were imposed higher than that, which I think Regulation 25(9) gives us a statutory basis for, but the appellate's point is that it wasn't justified. I'm slightly tempted to break for lunch at this time and come back maybe even slightly earlier, rather than embark upon a within 10-minute stop, because I suspect this is pretty quite a meaty topic. So if that makes sense, I suggest that we adjourn till 1:50 if that's convenient to parties, and address those issues then. Thank you. Right, welcome back. Good afternoon. Just to continue from the agenda for this morning, I think we'd adjourn slightly earlier for lunch to give us a clear run at item 3.3, which is the interrelationship between the BAT conclusions and the recommendations as this site, in relation to this site as represented in table 12 and 13, and the SEPA justification for higher levels for reactive phosphorus and dissolved nickel. And I guess I'll start with asking SEPA just to run through the thinking behind this. I've got a number of questions that others have as well, but just make your representations and bring in witnesses as needs be.
Thank you, sir. So, if I can refer to SEPA's submissions, this is dealt with in sections 4.2.9 through to section 4.2.21. So the activity that the discharge is coming from the treatment of leachate effluent, and this is a standalone waste management activity under Chapter 5 of Schedule 1 of the PPC regulations. The specific activity as set out in the permit is the disposal of non-hazardous waste at an installation with a capacity exceeding 50 tonnes per day by biological treatment and physical chemical treatment. Specifically, that's the activity under section 5.4A 1 and 2 of the PPC regulations. And BAT for that activity is set out in Commission Implementing Decision 2018/1147, which is the appellant's document 19. What we'll refer to as the waste treatment BAT conclusions. And under the PPC regulations, SEPA has a duty under regulation 44(1)D to review permits within 4 years of publication of the BAT conclusions, but this is the BAT conclusions for the main activity at the site. So in this case, the main activity at the appellant site is the landfill activity. So while we have the BAT conclusions here, that requirement under regulation 44(1)D isn't triggered. And SEPA has not yet reviewed the conditions of the appellant's permit relating to the specific waste treatment activity here against these BAT conclusions. So the basis for this variation was not as part of a review against the BAT conclusions. And this is really, again, to ensure consistency across the sector, in that we want to review the waste treatment activities within these landfill permits at the same time for all, I think it's approximately 20 permits across the non-hazardous landfill sector at the same time. As we've said in our submissions, the purpose of this review that led to the variation was to move the permit onto the new non-hazardous landfill template, and at the same time to ensure that any environmental limits within this permit were appropriate to provide adequate environmental protection. So the insertion of the limits for phosphorus, chromium and nickel in table 12 and the higher limits in table 13 were on the basis of to ensure adequate protection of the water environment in terms of our obligations under CAR rather than this being as part of a BAT conclusions permit review of the waste treatment activity against those BAT conclusions. If I can refer to the sections of our submission 4.2.15 to 4.2.17, we have gone into detail, however, to provide a comparison of how the limits that we've applied in tables 12 and table 13 on the basis of the environmental quality standards compare against those limits in the BAT conclusions. And we can see, as we've set out in some detail there, that with the exception of nickel, which the new limit falls within the what we call the BAT-AL range, the discharge limits that have been applied under table 12 and that currently apply do not reflect BAT. So these will still require to be reviewed and updated when SEPA does the permit reviews on the basis of the BAT conclusions for the sector. So as set out in our submission at section 4.2.21, SEPA has not applied regulation 25 subparagraph 11 in this case in setting the ELVs in table 13. However, there is a clear legal basis there to impose more stringent limits than what are set out in the BAT conclusions, where we do come to do that permit review. And had we applied regulation 2511 in this case as part of the BAT conclusions review, that would have allowed SEPA to impose the limits that we have done in table 13, because these are based on stricter EQS. So it takes us back to the same situation. So if the variation is affirmed in its current, with its current table 13 limits, I should also make the point that the BAT conclusions, and if I can refer specifically in document FCC 19, it is to, we're talking about BAT conclusion 20, and that is table 6.1. If I can, wait, what page is that now? Table 6.1 sets out the BAT associated emission levels, BAT-ALs, for direct discharges to a receiving water body. And this requires treatment of wastewaters in order to reduce emissions to water, and sets BAT-ALs for a much larger list of substances and parameters which are currently not in the permit, in particular the range of metals. So when we do the BAT conclusions review for this activity, further treatment will be required in order to meet these limits. We will be placing limits for more parameters into the permit, and we would have to be potentially reviewing the limits for the 3 parameters that this appeal concerns. And that would be done on the basis of regulation 2511. But at the point of decision making for this variation, we did not do it as part of a BAT review. And perhaps the other point just to make in terms of that interaction with BAT is that when we do come to do a BAT review against the waste treatment BAT conclusions, there is a process for requesting derogation from specific emission limit values. and that is under Regulation 2512 in document FCC 16B. However, part of the legal criteria for a derogation is that the value set must ensure that no significant pollution is caused and that a high level of protection of the environment as a whole is achieved. And in looking at that legal test for applying derogation, we would always look to consider whether there is a breach of an EQS. So again, it takes you back to the same situation of applying that threshold that is set out in the directions. So the EQS are threshold values that apply in both cases, whether we are assessing the discharge under CAR for protection of the water environment, as we have done for this variation, or whether we are carrying out the BAT review under PPC. Both defer to the EQS values. So should the variation not be affirmed and we go on to do that BAT conclusions review, we will be back in the same position where we are looking to apply those stricter limits set out in the EQS on the basis of Regulation 2511. Yes, thank you.
Before I go to the appellants, a couple of questions, I guess, from my perspective on all of that is there any reason that's you can give as to why that review hasn't taken place? I think there's information. I think, as I understand it, the kind of decision that came through EU sources requires a review to take place, I think, within 4 years. It comes to a day that's a date that's now passed. Is there any information you can provide as to why that wasn't done?
So the 4 year period that applies, that applies where the waste treatment activity is the main activity at the site. So that's what triggers that requirement in that 4 year period. So SEPA has conducted the review, I think now, of all the permits for which the waste treatment activity is the main activity against these BAT conclusions. But in this case, the waste treatment activity is not the main activity. So we have that longer period. I think we were delayed a lot with the ones that were the main activity, but we haven't yet done it where the waste treatment activity is not the main activity. And we want to do it on a sector basis to ensure that consistency for sites.
Can I just add a bit to that? Yeah. Sorry. Yeah. So in terms of that consistency as well, that review applies in England and Wales and as well. So we want to ensure that our approach to that is consistent across the country. So the likes of the appellant operate sites across the UK. So we want to ensure that delivery of that is done consistently, and we and so all parties, EA as well, are currently scoping out the scale of that work and that project and what was involved in doing that. So that's added to that delay in implementation.
And so the reasons for the figures then, just to make sure I understand what you're saying, the reason for the levels that are imposed are to do with the relationship with the EQS findings. And are you saying you get to the same point even if you did do a BAT-C review?
Yeah. So even through the BAT review, because of Regulation 2511, which gives that, effectively defers to the EQS values as well, you get to the same position. We would be looking at the EQS values if we'd done it under the BAT review.
How would you know you'd get to the same position if you haven't done the BAT review?
Because Regulation 2511 refers to those stricter limits in the EQS. So as we've set out in the, we've based the limits in table 13 on the EQS, and we'll come on to that in
Okay.
the next agenda items,
Yeah,
how
good.
we've calculated that. But they've been done on the basis of the directions in the EQS. So in doing the back review, if we were applying regulation 2511, we would again be going back to that same position of looking at what the limits in the EQS are and calculating them then on the basis of that.
So is it the position of SEPA then that the levels required are higher than the BATC conclusions?
Yes, so as we've said
Oh.
in, it's 4.2.15 to 4.2.17 of our submission, with the exception of nickel, the discharge limits, is that right, for the ones under the... So we've got the, in our submissions there, we've set out the three tables. The first table under 4.2.15 has the BAT-AL range, and that's presented as a range, so just to say also that that range, it doesn't necessarily mean you take the top of the range, you look at what the operator can actually achieve applying BAT. The second table is the table 12 limits that are currently applying under the permit, and that is very much based on what the operator can achieve at the moment. So as you can see, phosphorus is 20, whereas the BAT-AL range is between 1 and 3.
Was it 4.2.16?
Yes, so the current limit for phosphorus that's put in table 12 of the permit is 20 milligrams per litre. Under BAT, the requirement is to be between 1 and 3 milligrams. So even to achieve BAT, there would need to be a significant reduction. And then the limits that we've put in table 13 are presented in the table at 4.2.17, and that's the limits that have been calculated on the basis of the EQS. So that shows as well that phosphorus would appear within that range of the BAT conclusions. Yeah. No, I think in the case of, is it chromium would be stricter.
Well, I mean plus in the sense of being a more onerous or more rigorous requirement to be met, because the BATC provides a range, and
Yeah.
that range is now pinned down to something within the range. You don't know whether within that range it's the right amount. You don't know whether it equates to BATC, because BATC is a range, and you've now been more specific.
Yeah, but if you look at,
Like with the range, but it's
but if you look then at the table 13 limits, we are then stricter in the terms of, on the basis of applying the EQS, we have a stricter limit for phosphorus, for chromium, and yeah, all three of them out there.
and that comparison is tables 12 and 13. Is that what you're saying?
For table 12 at the moment, with the exception of nickel, the discharge limits wouldn't comply with BAT. And then table 13 are stricter than this, and they've gone stricter than what is BAT as well on the basis of the EQS.
My kind of related question before I go to the appellants on this is that, and you know, they vindicated very clearly that one of the key issues and the key difficulties for them is they say that the cost of complying with this is disproportionate and is too high, and so my question, I guess, is if these are figures that are applied just now, but might be reviewed when the actual review takes place, and might be different, and give you a new baseline to compare with. The new
So
requirements afterwards might be more strict, or there might be a decision that it's less strict. Or is,
So-
is that not the correct understanding of it?
No.
Okay.
So what we're saying.
I'm sure it's me.
No, because we've based the Table 13 limits on the EQS already, when we come to do the BAT review, which as I'm saying defers to the EQS as well, even if it's stricter than what is set out in BAT, that would result in the same calculation. So it's not that they would get stricter than the Table 13 limits, because we've already based the Table 13 limits on the EQS.
So you say there's no risk.
There's no risk that they would get stricter.
Yeah, so the question we're addressing is, let's say the appellants are willing to spend the money and think that that's something that could meet those limits. What my concern is really is there might come a situation that's predictable at this stage. Obviously things can be unpredictable, things can change unexpected in the future, but there's a predictable possibility that even if they spend all that money, it's not enough. And you'll go back and say, we've now done the review that we didn't do before, for the reasons you've said, you've explained the reason why you've not done the review, and you come at a later stage and then say, actually, there's more that's needed, and you spent that money, we need you to spend this much more.
What we're saying is that in the application of the BAT conclusions, there is more parameters that would need to be included. We've only included at this stage the 3 that were really of concern, and we can talk about how we've selected those. But there is a whole range of metals and other parameters that would still need to be added on the back of the BAT review, which would also require further treatment. So it would still require spend on the part of the appellant in terms of treatment technology that needs to be brought in to reach the other limits that we've not yet put in the permit.
And that's expenditure you see that will be incurred regardless of whether we're sitting in this room thinking about this.
Right, for some comments. The technology we're talking about to achieve the current Table 13 will also meet the BAT requirements because it's the level of the technology involved. So we're not worried about that. When BAT comes along, as mentioned, there's a derogation approach, and then the issue will be around no significant pollution. Alright? The issue then is around no significant pollution. So our argument, and unfortunately BAT is silent on carbon as well, so carbon emissions is not an issue in BAT, unfortunately. It predates all the carbon concerns. So the situation is when BAT's applied, we can argue there is no significant pollution, which is the case we have today. Therefore, these title limits are not actually relevant. The carbon costs and the financial costs of building this new plant, therefore, are not worth doing. So derogation is an argument we could have. Yeah. So the underlying all this is about significant pollution, and that's where the argument comes. But technology-wise, the RO technology will meet the BAT limits. We only have to do it once.
Thank you, that's better.
Sorry, if I can come back.
Yeah, absolutely.
Sorry, I want to read a question. In terms of applying BAT and the derogation that's available, it's not about whether there's no significant pollution. There is the legal test is set out in Regulation 2512, and it's about there's an assessment that has to be done, and that involves a cost-benefit analysis. But the assessment has to show that the achievement of those emission levels, as described in the BAT conclusions, would lead to disproportionately higher costs compared to environmental benefits due to and then there's the reasons, whether it's geographical or technical characteristics. It's not about there being no significant pollution. There's this cost-benefit analysis that has to be done, and you have to show that, and you're looking at the environmental benefits. So.
Great. The issues I was
Could I
looking at.
just
Yes, of course.
ask a question as well? So currently table 13, we've got a list of parameters. Are you saying that when we do a 4-year review, you want to expand that to match the parameters on the BAT conclusion?
Yes, there'll be further parameters that will be needed to be added on the basis of the BAT review.
So we'll match parameters, but not the AELs?
No, the BAT ELs set out in the BAT conclusions are the range that will apply, so we'll be setting a value based on what can be achieved within that range.
No.
If the EQS requires tighter standard, then that is what is applied.
That's fine. Let's just clarify.
Both a sort of a tabular range, but it also could potentially be other chemicals. I think you said the review might involve other chemicals.
Yeah, do you want to?
Yeah. So in BAT 20, so BAT, well, probably raise it better. BAT 20 sets out the parameters and the ranges that would apply. So that's already set out, and it's already visible to the whole to the landfill sector. Operators can and should be planning based on what will be coming at some point in the future. So they have visibility of what the ranges are likely to be and the parameters that will be necessary to be putting into their discharges. So it's already open information.
Yeah, just to add, the ranges in the value. So if we look at total phosphorus, it's that range of between 1 and 3 megagrams per litre.
Still interested in the interrelationship between the range in that sense of between measurement A and measurement B, which translates in table 13 for phosphorus to a 0.72 upper tier limit, and that's something that relates to the EQS. I'm still trying to get my head round the extent to which coming to that figure is a kind of arithmetic calculation.
Yeah, we'll come on to that in terms of we'll be able to present all the stages on how we reach that calculation,
Okay.
applying the EQS.
Yeah. At what point do we do that?
It's the next.
Next item. Okay, we'll come to that. Maybe. Yes, I don't know.
And I'm also conscious that Mr. Martin and Ms. Toon have had a word or two to say. Just for your notes, sir, the reference to the derogation, it's Regulation 2512, and for ease of note-taking, that is set out in paragraph 10 of the... Yeah. And while, sir, you're in the appeal document, it might be useful if you turn to paragraph 12, where, because I'm a Luddite, is set out in untabular form, and we see the BAT range under reference to the Commission decision, table 6.1. And the submission is made that the range reflects the nature of wastewater composition, that the nature of wastewater's composition will impact upon what can be achieved and not all components can be removed. And then the submission goes on, table 13 requires more stringent limits than those set out in the BAT conclusions, with the exception of chromium. That is acknowledged. But that doesn't mean that there isn't a basis for this appeal, because one still has to consider in the round table 13 and whether, as a generality, table 13 can be justified, which of course is part of the item we're discussing in the agenda now. I have listened with some interest to the submissions made both this morning and this afternoon by SEPA. And as I understand it, and this goes back to the question of the relationship between the BAT conclusions and tables 12 and 13 and the justification for higher levels. When we look to the SEPA response to the appeal, first of all in paragraph 1.3, one can see sorry, it was not 1.3. That's the setting out the reviews. It's paragraph 2 I wanted to light on. The current review was carried out as part of a sector-wide review, and we've heard some evidence about that. That is also reflected further on in the SEPA document at 3.2, perhaps in more detail, after setting out the concerns. Sorry, again, I've got the wrong place. It's the paragraph 3.1 and reference to the new template for non-hazardous landfill sites to ensure consistency across the sector. So far, so good. And then there's reference to controlling pollution and the like. We now know from the submissions made by SEPA that this is not a review under Regulation 44 and the 4-year review following conclusion of BAT. We know it's not imposed under Regulation 2511 because they've not done their BAT review. I'm not sure if the contention is made that it's being done under paragraph. Sorry, my computer's gone to sleep. There was reference this morning to Schedule 10 of CAR Part 2 and a variation under paragraph 9. I shan't take up time reading that because this will be a matter for submission, but paragraph 9 requires SEPA to carry out a review of authorisations which are now treated as a CAR authorisation. But of course we know from the chronology in this case that variations post-CAR were carried out. In my submission, we are in the regulations territory, and that takes us back to Regulation 25 and Regulation 25.2 in particular, which we looked at, and I think you, sir, asked some questions of the SEPA witnesses earlier. But we know it's a regulations variation because the variation itself says that it's a variation under Regulation 46 of the 2012 regulations. And if that is so, one has to root oneself in those regulations, which takes us back to Regulation 25. And that, with respect, in my submission means that you, sir, were right to look at what Regulation 25.2 requires, and it will lead on, obviously, to submissions as to the relevance or otherwise of the directions. And whether or not at some point in the future there is a review carried out under reference to that, while of course there is the Regulation 2511, SEPA has a discretion if the circumstances are justified under Regulation 2512 to set different values. But that's in the future, of course, because we now know that we're not in bat territory. It wasn't clear from SEPA's decision making, and if that's my ignorance, I apologise for that. It's useful to have had this discussion today. We now know we're not in bat territory, which gives rise to the question, what territory are we in? And it would appear we're entirely in EQS territory under the directions, for good or ill, and obviously, sir, you'll have to decide that particular question.
I confirm that's all correct. This is not a review under 44(1)D under the BAT conclusions. This is a review under Regulation 46, which gives the power to SEPA to vary the conditions of the permit at any time, and also sets out that we must vary a permit to ensure that it complies with Part 3 of the regulations, which includes Regulation 25.2. As Ms Crawford has pointed out, we inserted the Table 12 limits for the 3 parameters that were not previously covered, and we also inserted the Table 13 limits, and this is purely in the grounds of the EQS and the need to protect the water environment under CAR.
The dispute over the calculation. I am wondering if this is better for the 4th of March, if we can deal with this with the information we have today, or at least get an explanation as to the kind of parameters of where the dispute might be. I don't want to prejudice.
This came back to my preliminary point, just the order. Instead of putting 3.4 first over the calculations, if we could deal first with 3.5 and 3.5.
Well, we could do, yes, let's do that. Sorry, you're right.
And just
before dispute over calculation, we don't dispute the numbers, but we note the arithmetical error, of course. We don't dispute the numbers. The dispute is using an excessive VAT. I've now heard the explanation. I will have submissions to make about that. But the number crunching isn't disputed.
Okay, well that's it from that perspective. The meaning of what in the VAT.
So this comes back to the points we were making earlier about the application of the directions and the dual purpose that the directions have, not only for classification of water bodies, but in setting discharge limits for all of the water environment. So where, as we've done here, we're controlling a point source discharge to the water environment. That is defined in the Water Environment Water Scotland Act, Article 3.
So what's that? 2003 Act.
Article 3, Section 3, sorry.
Yeah, sorry.
Subpart 2. I know, going
Articles and
between.
sections. I thought you saw that.
I'm still in my EU legislation. So the water environment is defined to mean all surface water, groundwater and wetlands. Subparagraph 3 then defines surface water as inland water other than groundwater, transitional water and coastal water. And subparagraph 6 then defines inland water to mean all standing or flowing water on the surface of the land other than transitional water, and all groundwater within the landward limits of the coastal water. And these transpose the definitions from the Water Framework Directive that are set out in Articles 2.1 and 2.3 in document FCC 24. And so it's, as we'll come on to explain in the next item, SEPA's assessment of the impact on the water environment was based on the 2 points that we've got on the map, the reference to WPB, which was which was referencing the appellant's monitoring data set out in the Colmart report, and SEPA's monitoring point, which is 602612, which is just the other side of the road there.
Yeah, that was pointed out in the site visit.
The 2 points, and both of those are part of the water environment that we have an obligation to protect, and that is where the discharge, we would assess the impact of that discharge on the water environment.
And it says downstream. It presumably means downstream from WPA. As I remember it, the river, or the stream, flows down from around WPA, the water that's at the site, into it's already boggy and marshy at that point, but generally as a sort of flow of the water.
It came down to that point that we saw.
As I remember, it went into another stream at the side of the road. There was a road,
a small ditch,
yeah,
and then it crossed under the road.
Yes, it flows into a river. There was a ditch. I was shown a ditch under the road. Then we looked across further away from the site, and some farm units or fields that were latent to neighbouring farm units were pointed out.
And this is what we refer to as an unnamed tributary.
That's done named tributary. Okay, thank you.
So it's just to confirm that that is part of the water environment which we have a duty to protect.
Sir, I wonder if I might.
Just check that's
Sorry.
admirable brevity of that.
Yeah, that's all. It's just.
Water environment is of course defined in section 3.1 of the Water Environment and Water Services Act. No dispute is taken with the statutory definition, nor could it be. And the abbreviated definition of water environment is also to be found in the variation, where at page FCC document 3, page 57, I think it is, water environment is defined as all surface water, groundwater and wetlands. But what is disputed is, while that's a general definition, one has to consider what that means in the context of the site of the installation, not least having regard, as we know from the hydrology review, that the hydrology around the site is very complex indeed. But on a practical level at this stage, I wonder if I might defer to Mr. Martin to explain how this might, how water environment eventuates in practice and can be illustrated in practice.
Yes, please.
So if you're still on that page, read the definition underneath of watercourse. Includes all rivers, streams, ditches, drains, cuts, culverts, dikes, sluices and passages through which water flows, and includes artificial watercourses and underground watercourses. It's quite a broad term. So the scenario you potentially have is that any water in any drain has to meet the EQS requirement. So if you were a poor householder in Greengairs washing your car, you have to, your water going into drain has to meet the EQS requirement. The water quality requirement for Chrome is 50 micrograms per litre in drinking water. The water quality requirement on EQS is 1718 on me. That suggests that using water is not possible in Greengairs or Watson. So there is somewhere along here needs to be a level of practicality, pragmatism, where you measure EQS. Otherwise you end up in a scenario where you are forever chasing every ditch, cut, culvert, dike, sluice to achieve high quality water. And that I think is a difficult one, particularly then when you take into account the financial and carbon costs of achieving that. So it's a practical approach. I think we agreed Luggy water is a water body of concern. For my reading of the last few years, going back to 2019, Luggy water has good chemical quality, and we're talking about chemicals here. So the quality where we measure is good. We've decided to measure that quality there for a reason, presumably. Along that water body, the water quality will vary depending on what's added to the water, whether it's from a mine, or someone washing their car, or from a leachate treatment plant. So somewhere there has to be a degree of pragmatism. And our argument is it's not at point B.
If I could just come back on that, yes. Sorry. So we're not saying that any watercourse has to meet the EQS. We're saying this is the point at which SEPA is assessing the impact from this discharge. This is a point source discharge of pollution here, which we have to look at its impact and then decide whether we need to place limits on that and then how to calculate those limits. It's not that every person washing their car on a Sunday has to meet the EQS. That's not what our role is here.
If I may, sir, obviously Mr. Martin was, in a sense, taking the matter to extreme, but that was purely for illustrative purposes. The important point is one takes account of the impact of the discharge, but one has to consider the receptor upon which it's having an impact. And the argument for the appellant is that it's not just within the immediate vicinity of point B, and one has to be a bit more realistic, recognising that the water body of concern in this area is Luggy Water.
What you want to say? I was going to ask a related question. You go first.
Just to reiterate points that I've made earlier today, the Luggy Water is the classified water body, but that does not mean it's the only part of the water environment that is of concern here. We have a duty to protect all of the water environment, not just those classified water bodies.
I presume that position is consistent with the fact that sampling point 612 is where it is, as opposed to Luggy Water, which I think I looked at a map after the site visit, and it is something of 4 or 5 kilometres away.
It's a long way away.
It was pointed out at the end of the site visit where a river that was flowing, and it was, I think, Luggy Water, I forget the name of the water course at that point, but it entered Luggy Water some considerable distance away across that direction, if I remember it.
Absolutely.
That's right. Yes, it will be that sort of.
Cameron Byrne, I think, is the one. Cameron Byrne.
Cameron Byrne, okay, thank you.
It's not just Luggy Water, however, sir. There are points between point B and into Luggy Water, which again would be the contention part of
Well,
the.
yes. Well, take it in there. I wonder if I could just ask a question. I'm going slightly out of order, but it's just because this topic has been raised. Just more generally and more widely, and I suppose my question is first of all addressed to SEPA. It is just to say a little bit more about the approach you take to circumstances where, in taking sampling, you're aware of other particular sources of potential pollution would arise, and it strikes me there's a number of them. Mr. Martin given one example to make the point, but there's reference also to fly tipping and various other things, and there was also mentioned on the site visit in response to a question I asked, and there's questions about the potential for other things to enter the watercourse relating to farms in the area. And I suppose my question is, there's the sort of the car washing point, and I take it that's just an example for effect. I was more interested in the kind of the fly tipping and the sources from other particular users. I think you mentioned in terms of regulated bodies in this area, I think you said there's 20 or so throughout Scotland are in a similar situation to this. So I'm assuming there's no other regulated sites by SEPA in the immediate area for which you would apply your own standards, regulatory standards. So if that's right, then there is a risk or a possibility that pollutants are entering to water courses that come from other sources that are not regulated. And that could be people doing it perfectly legally, properly, not improperly, such as farmers and what they discharge. One way or other not regulated by you, perhaps regulated by others, but not by you. And the other is things that enter the water courses because of illegal activity, which by definition is not regulated by you. You'd be stopping it if that was the case. And it certainly was indicated to me at the site visit, I think at WPB, that this was a site of which there's quite a significant amount of fly tipping takes place. I don't remember on the site visit, and those who were there could remind me if I've just forgotten it, it's a long time ago. I don't remember seeing any evidence of fly tipping at that particular point, but I think it was a general discussion recognising that fly tipping did take place in that vicinity. So my question at a general level, first of all, is how does SEPA go about taking account of the fact that at any one sample point, regardless of how far the river Luggy Water might be, how is account taken of the fact that you may reach the view that there's likely to be a predominant cause? You may have reached the view that this is the predominant cause here. How do you, in general, weigh up the factors that take into account that other contributors might be, at least in part, causing or contributing to the results that you're then getting when you do the sampling.
If I can first just make a point about references to points, and that was very much why I wanted the map here today. So WPB is the point at the boundary of the site, very close to the boundary of the site. So the references to fly tipping and these other additional alternative sources are the second and third sites that we like quite some distance from there. They're over. They're downstream. Yeah. So in terms of our approach, and that's point that we take, we would always consider upstream sources, and I'll ask Olivia to come in here and talk about SEPA's approach now and how we do that.
And also might refer to Andy and Claire as well, because it's all part of the process. So yes, in terms of well, my involvement, just to explain, is I'm one of the principal specialists within the chemistry department and have reviewed the Colmart report and also established the monitoring locations from the chemical monitoring evidence that was submitted. So we had SEPA evidence that was submitted. There was a 12-month update to that report just recently submitted, and also the summary of the Colmart report. So in terms of reviewing the Colmart report, there wasn't actually an upstream sample that could be taken above the WPB point that had been submitted. So Colmart had undertaken sampling at WPA, which was the sampling point on the site. WPB, which was in the drain or ditch out with the boundary of the site, and then subsequent monitoring points further downstream. WPH is one of the control sites, or what was called upstream location, as a kind of example of background water quality of the area because of the lack of an upstream point at WPB. So we have used, we've reviewed the data at WPA, WPB and WPH, because that is reflective of the upstream, the discharge, and then the downstream point of the evidence that was submitted. We do recognise that there were additional monitoring points downstream along the unnamed tributary, the Cameron Burn and the Lugie Water from WPB, but we didn't feel that these were relevant in this case because the point of the EQS assessment was at WPB, which is that point immediately out with the boundary of the landfill site. So the other additional influences that may be impacting the unnamed tributary, the Cameron Burn and the Lugie Water are not relevant to the assessment point at which the EQS assessment point was done, as has been stated by Josephine already.
So does that mean there was no material difference in the findings between WPA and WPB?
No, so the WPA is the raw, the treated discharge coming out of at the sampling point. There is a reduction once it enters the drain, and because there is some dilution within the drain, but not much. Just to reference the SEPA monitoring point, which is a few hundred metres away at 602, 612, there was a slight difference again between those two locations, but not hugely significant. Phosphorus was maybe the one that had the most significant difference in terms of concentrations observed or detected. Obviously there's a passage of time as well, and there's other things that have happened on site and etc. as well. So our assessment point, based on the original Colmart data, which was the only data that we had available to us with regards to these, in particular these three chemicals of concern, was at WPA, WPB and WPH.
So I wonder if I might come in here. And again, I'm not sure that's working. It's flashing at me. And there we go. Red for go. I'm not sure if it assists the conversation and the discussion. It might assist my understanding, however, if we had a look at the Colmart report, which is FCC ENVE-003-255. Because I was interested in this discussion about choice of sampling sites, and if I could invite you, sir, and indeed perhaps Miss Downey, on page 3 there's a table 1, which sets out a number of sampling sites, and they're described, or sampling locations is the name given to them. And I just observe in 2.21, sorry, I was seeing that
a system to get me into this that's not that wasn't, I didn't have it up. Give me 2 minutes.
not us.
Screen. Next 2 minutes.
The most challenging thing about inquiries is managing the paper.
So it's document 30, you see,
Yes, please.
which is so what's that? That's a contact.
The Colmart report, Colmart. And it's dated from November 2020, and as I understand it, to a large extent, and I have something to say about the submission, set and train the variation. But leaving that aside, it's just to locate ourselves. It may assist when we're talking about sampling locations to look at table 1 on internal page 3.
Page 3.
Section 2, headed up Geochemistry Update. And just for context, we can see in 2.21, the sampling locations are based on the original sampling locations undertaken by SEPA in December 2019 and repeated within the ecology assessment, and we have that report. And you can see, sir, a number of locations are listed and described with whether they're upstream or downstream and so on and so forth. And then again, scrolling down, we can see a couple of maps,
Oh yes.
which again may assist. And there's a further map over the page. Now, just pausing there, it may be in due course, and now's not an appropriate time in the agenda, I suspect, to look at it, but there is the hydrology review again, which in very broad terms, and I know I'm being oversimplistic here before SEPA interrupts, but the hydrology is very complicated here. So I hear what SEPA say, but I think it's important to bear in mind that the sites which have been sampled at SEPA's request are not restricted to WPA and WPP. I can understand why SEPA are relying upon that, but
So there are a series of others, aren't there?
there are a series of others, and as I say, I can come on and discuss this at a later point in the agenda. I'm not quite sure where it fits in, but it does fit in somewhere. I can't remember where now.
Well, I had the issues around alternative sources of pollutants.
Yes, that well, maybe. The general point which Colmart make is that, and indeed I think the hydrology review as well, is that there is an insufficient data set to come to any firm conclusions. That's the general point. And and with respect to SEPA, we're no further forward with that, other than the ex post variation when they've carried out further data monitoring after the variation. So that's the point I would wish to make. Sir, and if we want to look at this in detail, now might be an appropriate time. I'm not sure. I'm in your hands very much as to whether we look at this in a bit more detail, and also the hydrology review.
And all of that's consistent with what we'll deal with this in the adjourned reconvene time in March. That's consistent with the recognitions that were lodged yesterday.
Indeed, and that may be an appropriate time to actually deal with this more detailed discussion of these reports. I accept that. But as I say, I'm very much.
So
But that's also consistent with the basis of this appeal, which is, in our submission at least, one doesn't just focus on WPB, looking at water environment, taking regard to the environment as a whole. I'm repeating myself.
And it is useful on that point about the fact that there are a series of number of other sampling points. Just sort of going back to the kind of the topic of this set of questions is around how SEPA would generally approach the circumstances where there are competing and alternative sources of pollution, both in identifying what they are, and the argument for the appellants is that's not been adequately done, but also making an assessment of how that plays into the question as to what standards are expected. And there's an issue I've got, and I suspect this is a science, not an art, of how you actually work out if you've got a user that, if they're accepted as being the sort of predominant cause of what's happened, what the pollution figures and results. If they are still the predominant cause, how then do you achieve an acceptable level of precision in what you expect of them when you've all these other players that also, or other factors that also come into play?
So if
I
I
think
can-
the answer is given to a certain extent is that SEPA were satisfied that these other factors were not significant based on those two sampling points, and that's been challenged as whether it's adequate or not. But I'm just interested in that sort of generality of how you reconcile in carrying out your regulatory functions, that difficulty of being able to be sure that the particular contribution towards the problem is caused by people in FCC circumstances.
So if I could just first of all pick up
course,
about
so-
the
so-
point about
yeah.
insufficient data. So we're talking about the points here at WPA and WPB.
Yeah.
This is chemical data that shows a breach of EQS values, and we've had no suggestion that that is challenged. We understand that there's a challenged ecological sampling, and that's to be held over to the next hearing, and obviously different conclusions can be reached, and there's questions about interpretation of that sampling and data. But we've had no submission that the chemical data, which is what we have based this assessment on here, and which Olivia was going to come on to talk about how we do that, at these two sampling points, I'm not sure how that can be disputed. It was based on the appellant's own data at that point, which was provided to SEPA, and then SEPA did their assessment of it. So it would be useful perhaps if the appellant could confirm whether they are disputing that data now, because that has not been brought out in the submissions to date.
The data is not disputed. What is disputed is what you make of the data, of course, in the context of the variation and whether that was justified. And part of that, as was partly relevant to that, of course, is the ecology status as well, because what is the impact of these exceedances? And the submission will be made on behalf of the appellant that there is no significant impact on the water environment, at least as represented by ecology. We don't say, and I think we clarified this in correspondence with you, sir, we don't say there's no impact, but we say there's no significant. Yeah. Yeah. Again, sorry, sir.
I'm conscious that I've probably interrupted the flow of the evidence.
Perhaps
I think
yeah,
the problem. I think the apology is due from me.
Yeah, perhaps if we let Olivia continue on, and just to say, we'll come on to the other agenda item about the alternative sources, because it's really about those downstream sources, and for the purposes of this assessment and looking at WPA and WPB data, we have not identified, and the appellant has not identified to us any upstream sources which would have brought into question that data at those points.
I was going to ask about upstream sources as well, so that's helpful.
But I'll hand over to Olivia now.
Yes, so I agree with Josephine, yes, that upstream of WPB there's been no identified sources that would impact the concentrations that we've observed or that has been detected during the investigation in 2020 or subsequent investigations. In terms of assessing, you know, the additional monitoring points downstream of WPB are useful in understanding the wider extent of any potential pollution from this site and then other influences. SEPA has itself done extensive monitoring downstream of 602, 612 to understand the wider impact on the catchment if that was necessary. But in terms of this permit review in the context of the EQS assessment, essentially the EQS assessment at WPB is trying to identify a potential impact at the point where the discharge is entering the water environment, which is the point at which we need to establish where there's an impact and then set appropriate controls off the back of that. The data that was submitted to as part of the Colmore report has shown, or we've demonstrated that there were EQS exceedances at WPB, and essentially what happens then is that triggers a decision-making process to undertake a permit review, because it's felt that there are insufficient controls within the actual permit as it exists just now to minimise the impact from the new substances that were identified, in particular phosphorus, nickel and chromium. Other substances were identified within the water body from the discharge, but weren't exceeding the EQS at that point, or there was no relevant EQS. For example, nitrate is at significant levels within the water environment, but there's no specific EQS set as yet within the directions. But we do have concerns about the level of nitrate within the environment at that point too, which was in the submission. So it we had raised that point, but so that the report that was undertaken in 2020 and then updated in 2023 and 2026, they're just really just providing an assessment of the Colmore report, our interpretation of it, if you like, or the findings, to support SEPA in actually undertaking the variation to set the control limits. We'll come on to how those limits are set with Andy and Claire, but that EQS assessment is just identifying there is an impact at this point, this assessment point. The other influences would be taken account of, and Andy and Claire can probably explain how those other influences would be taken account of, but those other monitoring points are really just explaining the extent of impact rather than impacting the EQS assessment at this point, which is what triggers the permit variation, if that makes sense.
Do you want to add anything about on those points about the other contributing factors? Nothing to add. No, don't feel any obligations.
Sir, I wonder if I,
Yes, of course.
and again I've listened with interest to the explanation, and it's, I realise we're in a hearing session, not an inquiry session, and my observation rather than a question is derived from ignorance on my part, but in the Colmart report, again as a generalisation, when it discussing nickel and chromium, and I think phosphorus as well, may be wrong, talks about seasonality and the like, and I just would be interested to know what account's been taken of seasonality and the
That's
like.
a good question actually, because that's one of the very specific things that's raised in.
It's in the ecology report, but it's also in the Colmart report. And for example, sir, you may care if you've still got the Colmart report to look at internal page 13. And paragraphs 2.5.2 and 2.5.3, they're
I've got that here.
and 2.52 talks about seasonality, putting it very simplistically, and 2.5.3 talks about the EQS for nickel is based on a bioavailability target and therefore is not directly comparable, etc., etc. And a similar point is made in relation to chromium at internal page 16. And I'll have to refresh my memory if something's made about phosphorus or not. Perhaps not. And then what Commerce say, drawing that all together at internal 19 when discussing surface water quality. And this picks up on something which we discussed a moment or two ago. In summary, the geochemistry indicates that the discharge from the site WPA forms a significant proportion of the flow within the receiving water unnamed tributary. The concentrations are highest at WPP at the point of mixing, and while there's a minor decrease and so on and so forth, there is no significant dilution. This is consistent with the findings of the ecological assessment which recorded water quality pressures at the locations. The water ecology had improved by point WPC, etc., to moderate and good by WPT. But I would be interested to know about the seasonality and what account, if any, SEPA took of that.
Very happy to answer that question. There are a couple of things. One is seasonality, and another issue that we will talk about later was about the number of backside.
I think that will definitely be for March.
That will definitely be for March. So yeah, so I flagged that.
I don't have a witness today to speak
no,
about that.
I don't want to speak about that. I'm just flagging up the fact that it's an analogous point. We'll deal with it later. But yeah, on that question, that's a very specific issue about the extent to which seasonality has an impact and was taken into account in reaching the views and decision-making processes.
So the EQS is based on an annual average. There's generally two standards within the directions, but in this case, because it's a continuous discharge being released on an ongoing basis, generally a minimum of 12, 6 to 12 data points are kind of recommended to understand variability throughout the year. In this case, there was 11 data points over the course of the period that was sampled.
A data point is a time of year.
Just an individual sampling point, the data from that sampling point. So,
all right, so it's not a January, February. When you say data point, that's not a data point. There's date related. It's a physical data point. Or am I misunderstanding?
So it's a result from a sample. So a data point. So for nickel, for example, there was 11 nickel measurements over the course of the period that they were sampling, from February to October. In terms of, we would recommend for statistical kind of confidence generally when we're undertaking sampling, we would recommend 6 to 12 data points over the course of a year for an annual average assessment, so that we could have confidence that seasonality was taken into account in that assessment. So because that's why we submitted a 6-month SEPA data report and then updated it to 12 months, because the 6 months gave a partial year assessment, but the 12 months gave the full year assessment, a full data set, which is kind of recommended over the course of a year. So in this case, again, the 11 data points were averaged, which is standard practice for assessing against an annual average EQS, and then that information then was used in the assessment against the values. So it's not, individual results are not individually assessed. It's the average of the data that is taken. For ammoniac, nitrogen and BOD, it's a 90th percentile, which is again considering the full spread of data. So that seasonality is kind of incorporated into the assessment already. Hopefully that answers the question. I don't know if I'm getting all the points across that Claire can chip in.
I understand the issue, whether point we're taking as to whether that's appropriate to average out. But what I'm taking you to say is that the date at which samples are taken. That's part of that compilation of the data set
Yeah, so
in a way that is properly representative.
so the EQS itself is based. It is derived such that the data that is used to assess against the EQS is an annual average. So we have something called an annual average EQS and a maximum allowable concentration EQS, and both of those are within the directions. In our case, we've applied the annual average EQS, which is using the full data set that was provided, which accounts for the seasonality within the data. So the EQS actually is an annual average based EQS, so we should use a full year's, ideally, data.
Use the full year's data.
Yeah.
I'm going to ask a question I regret asking. Are you able to say anything about, even at the widest level of generality, about how much variation there's liable to be in EQS figures within any one year? When you're talking about an average over an entire year, it strikes me that if the readings or recordings, the results that you get, are massively different according to the time of year, then that tells you something. But if at the end of the day, yes, they vary, but the general range of variation is within a kind of a tolerance of a sort of a relatively limited percentage, that tells you something different. I don't think does that question make sense? No.
Perhaps not. I mean, in terms of the EQS itself is derived such that we should apply, a full year's data to take account of that variation. We can look at if there are significant exceedances over the summer where it's maybe less dilution, it's drier, etc. But in terms of the compliance assessment, it is an EQS that is applied based on an annual average data to account for that variation, basically. So the maximum allowable concentration is used in circumstances where we think there might be a short-term impact. So if you have, for example, a slurry spill or something where a tanker falls over, it's a one-off discharge. You might apply a maximum allowable concentration at that point because you recognise there's going to be an intense impact, but it will be short-lived because it will flush through. So in that case, the slurry tank will go in, it will reach the river, and then it will flush through, and there isn't a continuous discharge for 12 months, for 5 years, whatever it is. So in that case, it could be justified to use a maximum allowable concentration, and generally they're much higher than an annual average EQS because it's recognised that it's a short-term impact, whereas the annual average EQS is trying to take account of a continuous discharge entering the water environment over a long period of time, and so will have a sustained impact on the water environment, and so you need tighter controls because it's continuous and continuous and continuous, and the ecology within the water body is continuously impacted, whereas in that slurry example, it's just flushed through and the environment might be impacted in a short term but can recover reasonably quickly depending on what happens.
But that seems to make sense in the sense that you presumably don't make your assessments where there's been a kind of pollution incident. You have other things you do if there's a pollution incident, but you wouldn't draw conclusions that will have long-term implications if something can get put down to an event that's happened that hopefully will never be repeated. So it presumably is an endeavour to get a typical range of information.
Yeah, and even within the directions, there's intermittent standards, and there's there's annual average or long-term standards that are used. So actually, one thing within the Colmore report was that they had used an intermittent standard which wasn't actually appropriate in this case because it's a continuous discharge, so that's not an appropriate standard. But if somebody was discharging once a year or once every 3 years, you could justify the use of that standard, but in this case it's a continuous discharge, so that EQS assessment for ammoniacal nitrogen wasn't appropriate in that case in this report, and we contested that in that 2020 report back, which we hoped would form part of the discussion that would happen. But
myself. I'm still interested in the degree of variation that happens across different parts of a year, as how different readings are typically in different seasons.
We'd be very site specific, you know. I mean, you know, for example, this last year, there was a lot of water scarcity issues on the east coast of Scotland, you know, there would be much less dilution on the east coast of Scotland compared to the west coast of Scotland, and so there would be, you know, for example, groundwater base flow would be a significant input into the surface water environment in the east coast of Scotland, which is something that we had to take account of or recognise within our data, whereas in periods of high rainfall, like, you know, this week, we would have to recognise that as well. So I think the annual average EQS is developed in such a way to, I suppose, recognise that there will be variation over the course of the year, but this is the threshold above which you start to see impacts within the environment. And I just wanted to touch on something else that I thought was relevant to pull out in terms of the derivation of the EQSs. The EQSs are derived based on ecotoxicological data, which is trying to provide an estimate of ecological impact, but the indicators that are used within that testing are not directly related to the ecological testing that we do on a routine basis within SEPA, and it is widely used in scientific assessment. So for ecotoxicological data that's used to derive the EQSs, it's based on tests on bacteria, on crustaceans, and on fish, to try and give a breadth of understanding of the effect a chemical can have on the environment across a wide range of flora and fauna, basically, that can exist in the environment. So obviously the testing that's done as part of the ecological assessment, which obviously will be discussed in March, but that's only reflective of some impacts, ecological impacts, but chemical testing, or the chemical EQS, is derived to also consider a wider range of ecology that could be impacted by chemical releases into the environment. So just wanted to bring that nuance out, because the ecological testing that we've done is just one part of the story of what happens in the environment. The EQS is also explaining the potential ecological impact on crustaceans, on fish, on bacteria, as a kind of indicator of what might happen to other species that exist, not just the ecology testing that was done as part of the March discussion. So I just wanted to bring that nuance out as well.
I had only one further question before going to the appellants on this, and it goes back to Mr. Martin's point, really about different potential sources and causes of impacts. Certainly the levels are set relate to substances that are presumably quite unpleasant substances, and you don't really want to have them in your tea. Reactive phosphorus, dissolved chromium, dissolved nickel. Is there anything you can say about the other potential sources? We mentioned people they do things when they wash their car and the like. But I'm quite interested as to whether any other potential sources, how likely it is that any of these other potential sources would give rise to the presence of these particular matters. So I can see that somebody who's washing the car, or somebody who's even dumping, the illegal dumping, whatever, I'm not completely clear why it would be, or even what farmers use, and they use nitrates and the like, but why they would lead to high levels or concerns about these particular substances, as some might be naturally occurring substances. But I just want to understand. I mean, it does reflect a bit my ignorance of chemistry. That I would imagine that some of these things are not frequently naturally occurring, and how that's taken into account in working out the sourcing, which again links into the question of how you would want to apply these particular factors to this particular site, effectively. And both sides may have a comment on this. Mr. Martin B. Do you want to go, Mr. Martin, first? Do you want to?
I'm going to upset your tea drinking.
Yes.
The Chrome standard for water using your tea is 50 micrograms. Nickel standard is 20. So the limits we've got here, I'm using that example, suggests that crustaceans don't like to be in our drinking water. Now reality is the environment is a much wider thing. So they are naturally occurring. Chrome and nickel come from rocks. They're in the water sources, they're in the groundwater. We have limits on our drinking water to ensure our safety. Sometimes the numbers are higher than what is acceptable in the environment. In this case, for chrome, that's the case, for our particular example. So, unfortunately, they exist, they're all around.
I guess my question a bit here is, if they exist generally in society, but the standards required here because of what's found are higher, I suppose my question is why then? If it isn't FCC, it must be something else that's causing
I
it.
think I was going to ask a question myself. Unless I've missed something, EQS is applying to all waters. EQS is a standard which are single numbers, which apply to all water. So the type of water, the fact it's the River Clyde, no, don't pick the Clyde, it's tidal. Pick a non-tidal river in the local area, and pick Cameron Burn, and pick Point B, they'll all have the same EQS. Yes? Yes. Which is the point where we're talking about as if EQS was a number that's derived each time. It's not, it's a set standard across. Right? And the naturally occurring element comes into it. If you are near a mine watering area, your water quality will be poorer than if you're in the lowlands.
But the EQS as applied at this particular site is informed by the sampling.
No. The EQS is fixed. The EQS
No, but the findings and then the comparison with the EQS to work out whether additional
the EQS is
restrictions.
there.
I know the EQS isn't.
The EQS is fixed.
Yeah.
It's whether our water at that point is above or below the EQS.
Yeah, exactly.
Our argument is we accept at that point it is above the EQS for some parameters, but at that point is not a point for measuring EQS because further downstream other things come in, the water quality dives again, increasing and dives again. And the point where we are concerned about is luggy water,
Sure. Yeah.
where water chemical quality is good. And it's back to my earlier point, if you were to apply the EQS when you're washing your car, you could be in trouble because the chrome level for drinking water is higher than the chrome level for the EQS.
And sir, I wonder, sorry, my eyes have alighted on another passage in the Colmert report, which picks up on Mr. Martin's comments there a moment ago. This time I'm looking at internal page 28, paragraph 4.2.9. Where Colmert, who of course were the appellant's consultants, say this: they recognise it's not desirable to exceed the water quality standards following initial mixing, and I can repeat that recognition on behalf of the appellant. It should also be recognised that this event, this is their calculations, and I realise it's disputed by SEPA, but their contention is the event is extremely transient and associated with periods of dry weather when flow within the receiving water body is low. Under average flow conditions, only chloride and orthophosphate are above the EQS at the confluence with the Cameron Burn. And then they quote from guidance, which I don't think is in your paper, sir, Watt RM34. But I was just double checking, I couldn't see it. But the quote may be of some interest, if it's accurate. No. So, operating on the presumption that the guidance, that the quote is accurate, a proposal may cause damage by breaching an environmental standard, but not cause deterioration of status of a water body because the geographical extent over which the breach occurs is too small. Such breaches may nevertheless adversely affect third-party interests. Again, sir, you'll immediately appreciate why I've drawn that to your attention because it very much reflects the basis for this appeal, for good or ill.
And I seen as not an absolute standard in that sense. I mean, it kind of is another variation, I suppose, of the pollution incident. An individual pollution incident requires to be addressed as a pollution incident. That would not in itself
Indeed.
result in a justification for the imposition of the levels.
A much used phrase in law, at least, in law, context is everything, and I would suggest that in controlling the water environment and pollution incidents, context is everything as well.
Could I just come in to put that in context, that quote that has been put to you? So that does not form one of the productions for the appeal, but that relates specifically to derogations for the water environment. We were going to come on to talk about that at a further agenda item, but that does not apply here. So that is looking at deterioration of status of a water body, and where derogation would be applied under the Water Framework Directive, strict criteria again, and not relevant in this case.
If I may also jump in, for example, when I've examined the chromium data, for example, every single measurement that was taken over the Colmart investigation at WPB exceeded the EQS. So it's not, there's no seasonality in terms of the EQS exceedance from that point of view. So we have contested some of the information contained within the Colmart report in 2020, which we never got the opportunity to agree an amendment to the findings within the report. So just want to call some of that out. So just in terms of the seasonality, that's just an example of, yes, there may be variation, but for both the phosphorus and the chromium, each of the data points individually over the course of the year exceed the EQS. With nickel, I'd have to look more closely because it's actually a bioavailable standard. So just talking about that element where there may be mining influences and things like that, the bioavailable standard for nickel is actually a site-specific standard that's derived, taking account of other influences like calcium and dissolved organic carbon and pH. So that's something that's included within the development of the EQS. Well, the metal behaves dependent on the site-specific conditions based on based on those concentrations. So that's why there's a site-specific EQS developed for that. Phosphorus is also a site-specific or region-specific EQS that's developed, taking account of things like altitude and alkalinity, which affect how that chemical behaves in the environment. So there are some that are set no matter where they are, but some EQSs are based on site-specific criteria. So just wanted to kind of come back on a few points there. Oh yeah, so just there was quite a lot of points being raised, obviously in all of this discussion. I just wanted to draw. I wanted to draw your attention to Table 3 within the. I'll have to tell you the SEPA document number was SEPA document 21. If I've got the right number, obviously there's going to change to the document numbers, but on page 8 of the summary report, I've compared. Yeah, sorry. So it's the summary. The summary, yeah, of the 2020 Colmart report. What I've put in Table 3 is a comparison between the data at WPA, WPB, and WPH. So WPH is that background level, an example of the likely concentrations that you might find in the area if it wasn't impacted. And if I draw your attention to this is in relation to relative exceedances, so risk ratios. If there's above 1, then there would be a cause for concern with the chemicals that we're looking at. Obviously, the discharge would expect high levels. I'm not disputing that. It's just for comparison purposes. So if we look at WPB and WPH, the comparison of the findings across those two data sets are that there's exceedances of EQS at total ammonia.
The reference there on that, I've got the up in front of me.
Oh.
What page are you on?
Page 8 it's table 3.
Oh yes, that's it. Yes.
So comparing the data at WPH, that's what has been detected in an environment that hasn't been severely impacted by a discharge. Obviously, the numbers above 1 in WPB show that there is an exceedance of EQSs and a lack of control. So obviously, you can see for phosphorus that the number is significant. And there are exceedances for dissolved chromium and dissolved nickel at the bioavailable standard. As you can see for WPH, they're all below 1, and in some cases significantly so, which show that yes, there is chromium or nickel detected, as has been quite rightly pointed out, that there is a general background of these chemicals within the environment, but not at such a level that they would cause an exceedance of the EQS in this instance. Whereas adjacent, downstream of the discharge point, there are significant exceedances. Phosphorus is, there may be, there may be phosphorus, chromium and nickel, as I say, within the environment, but not at the levels that were observed at WPB. So WPB is the downstream point just below the discharge.
If they're in the environment otherwise anyway, as it was, there could be different figures at different places. So you're saying that table indicates a suggestion as to where the source of that is, even though it can appear naturally. But if it appears naturally, I'm looking at the fact there's a difference in the figures, and trying to work out what conclusions.
I think what we're saying is, if it
that.
appears naturally, looking at that WPH point upstream, the levels that are appearing naturally are significantly below 1.
That's what I'm kind of driving at in trying. But I'm also thinking that there might be reasons, even naturally occurring reasons, why there could be differences in these places. And obviously, that figure shows quite a startling difference between them. There's no doubt about that. But I just wonder whether it can be targeted at face value.
I think we've, as we've set out before, we've not had any other upstream sources identified by the parent to us, and we've certainly not identified any.
And also in the derivation of EQSs, these are, in many cases UK-wide or European-wide standards that need to be met across Europe. And obviously there's a huge variety of geology, etc. And within the EQS assessment that's used right across Europe, there isn't an account taken for background quality. It's just this is the level at which there is an environmental impact. So it's not part of that kind of wider assessment process. So yeah, just to be clear on that. These are the thresholds that are in legal statute that must be met in the environment. That's what's.
I'm conscious that as I'm sometimes guilty of drifting out of order with the agenda, and I've moved on to what was items issues to be addressed at item 3.9. Just to try to apply some kind of discipline to what I'm doing this afternoon. Can I ask if is there anything anybody else wants to say about 3.9, the alternative sources of pollutants, or do we think we've covered all the information that's relevant, at least for today, today and tomorrow, to cover, and regard that as covered in the agenda, or is there more to be said?
Just this, and it's a point of clarification, yes, and I should know, it's not, I'm asking for a point of clarification for SEPA much as anything else. As I understand it, it was at the instance, I may be wrong, of the appellant that they identified an upstream point. As I understand it, SEPA have never themselves sought to identify an upstream source. They've just consider, for good or ill, that you look to WPA and WBP rather than looking upstream. I may be wrong about that.
Well, in the development...
and if I am, excuse me.
in terms of the review that we did in 2020, that was based on the Colmert report. We've obviously established our own monitoring programme since and have been unable to undertake monitoring upstream. That was also the case for ecology, which was undertaken in 2019 and subsequent years, obviously, which will be discussed later. So it's not been possible to actually physically take a sample upstream to understand that upstream influence, which is why the numerous control points were taken on the Cameron Burn downstream, but upstream of the confluence.
Is it where Stephen just has a point on this as well?
Yeah, or maybe there's been quite a lot of input from our science colleagues, but from a site-based kind of regulation point of view, we did carry out a site walkover in 2019 to assess the connections between the site and the burn, and it was our understanding at that point that the landfill was the top of the catchment, and I believe from the Colmert report that was potentially their take as well, that there was no upstream point to take the sample. That's why WPH was sought as a control site that reflected a background water course in that area. So it was our take at that point that all alternative sources were downstream of those assessment points.
As item 3.5a, and that's the history of compliance on the site, and we'll deal with the implications arising from that on the 4th of March. But I didn't find it all fully clear in my mind all of the sort of the nuances of the background understanding of it, and I think I was possibly misled a little bit by maybe me misreading an aspect of the joint minute of facts as to how much of the information in the SEPA data that was provided and identified back in 2019 had been made known to the appellants. There was some suggestion that only some of the documents had been, but those that had been contained the information in the other documents that hadn't been, if you see what I mean. So there was no prejudice to the appellants. But I was just curious, thinking back of the fact that since around 2019, which is now 7 years ago, there's been this underlying dispute or failure to agree on things like the recording of the data, the information, what that means as to status and the like. Now, the interpretation of that will come to at a later point. But I'm just, and I certainly recognise that it's always a risk that people in this environment don't reach an agreement over facts. That's perfectly possible. The reasonably people could easily disagree. But I just want to maybe ask both sides just for a little bit of a kind of potted history, as effectively in a sense as to why it has apparently proved so difficult to find that common ground as to how to interpret the data. And it is suggested by the appellants that for understandable reasons the appellants instructed agents have been able to apply a more thorough approach on the site, whereas it's been suggested that SEPA, who have wider responsibilities, have maybe spent a little bit less time on the site. You may dispute that, but that's what the suggestion is. But I'm just interested a little bit in looking at the kind of the older history, and I'll come to the relevance of that for my decision making once I've heard you. But I'm a little interested in finding out a little bit more about that kind of background history, just as hopefully a kind of reasonably clear narrative background as to why both sides are still so far apart effectively in what the if you like the scientific data actually means, that's led to a situation where we're all sitting in this room together. I'm going to start with SEPA.
Perhaps if I just bring Stephen in just in terms of the history of it in 2019, starting with the compliance assessment that was done then.
Yeah, I can give a narrative there. So 2019 was the initial meetings that were held with FCC. The trigger for those meetings were through SEPA document 9, the WRU review, which assessed the 2017-2018 annual monitoring report from the site, from FCC. That flagged that there was high concentrations of particular metals and other parameters that SEPA would seek to control. At that point, it was then that then triggered the first ecological survey to be undertaken around about the 18th of December 2019, and that again led us to that there was an impact from the landfill site, from the leachate. A site meeting was called on the 20th of December 2019, and at that point the site were advised that they would be marked as a significant breach of condition 711 in the older permit, and that's essentially due to they were meeting their limits. The treatment plant was performing in terms of meeting the limits for the ammoniacal nitrogen, biochemical oxygen demand and suspended solids, but there was a catch-all condition which required them not to have impact and damage flora and fauna from the site. The inspection report that was issued to the site at the start of 2020 invited the operators to set out an action plan of how they intend to bring the site's discharge back into compliance. That triggered the conversations around COMERT and the COMERT report, which was carried out throughout 2020. At that point, we should probably say that at the end of 2020, SEPA had quite a significant cyber attack, and we were essentially offline for quite a considerable amount of time. However, we continued to send our ecologists out to do surveys throughout 2020. I think there was 2 surveys in 2021, sorry. And as I touched on previously, the SEPA set up a specialist landfill regulation team in 2022, and at that point we sought to pick this issue up and try and drive it towards a conclusion. We felt that the best vehicle to drive it towards conclusion would be a review of the permit, because we knew we were doing the SEPA-wide sector review with the new template. The other options at that point would potentially be issuing enforcement notices, and those types of options were on the table and were considered. But we felt that the SEPA-initiated variation would hopefully stimulate a more open dialogue and consultation with the operator. So as part of that review, as Olivia's touched on, that we reviewed the COMERT report, identifying the contaminants of concern. That started a 12 to 18 month dialogue with the operator, where we had separate groups looking at groundwater monitoring, surface water monitoring, leachate composition monitoring within the new permit template. SEPA then conducted their own enhanced monitoring, which Olivia can talk to, SEPA document 22, which ran from November 24 to November 25. The permit was then issued in 7th of April 2025. So I hope that gives a bit of a narrative of where we were and how we've got to this point.
Nuance differences.
In your perspective.
I wasn't in the meeting in December, received a part of the report, because the rest was still to be prepared, saying we were causing ecological damage to the stream.
When was this?
December 19. 23rd December 2019 to be precise. Right, yeah, it was. Which was, that doesn't seem right. We've not changed what we discharge, and the process hasn't changed. And an ecology survey in December, that seems strange. February we saw the full report, so early 2020. At which point, right, we need a consultant on the chemistry, and who can we talk about ecology? So we set off 2 different sets of people to actually look at what we're doing. Had something changed and we weren't aware of it. So the COMERT report was done, because that was the easy one, once the sampling was done. Assessment was made based upon today, on a slightly different approach, we were not looking at just point B, we were looking at the stream as a whole, and Luggy Water as a receiving point, as the ultimate point. So the scenario of you must immediately at point B immediately correct was not one we considered, it's not one we're used to. No, I think it, nor is it. I'm not sure if it always is the case. I certainly can find cases where it's not. So off we go with the reports. We get the council report. The ecology report required a longer period of time. It required a number of assessments during the year. Sen said do over a period of time. Right. We had a meeting, I think in 23, and then obviously in this time there was problems with COVID and the failure, etc. Yeah, I forgot about COVID. Remember that? Right. So there was one meeting at Greengairs, which was quite a feisty meeting. Disagreements over approaches and over interpretation. Right. There have been conversations going on in the background over leachate monitoring, groundwater monitoring, but to be honest, until the permit first draft arrived, that was the first time I was aware of changes to surface water monitoring.
And was that,
The high flow monitoring, sorry.
as I read the papers, I don't think there's a document, that was the arrival of that information led, I think, to the correspondence with Ayesha and
Yeah.
SEPA.
So here's what we're required to achieve.
That's right. I think the first of that letter said, we've received your request for that. I said, that doesn't matter, let's see that, because it just says a
So
request.
technology-wise,
That
yeah. So seeing the numbers, technology-wise, it's quite clear what technology is required.
Yeah.
It isn't very many options around that levels to be achieved. And then the question then comes to saying, this doesn't seem right
Yeah.
for the body we're talking about, and based upon the ecological evidence we had by then, and the chemistry evidence,
Yeah.
it felt disproportionate, hence the challenge.
Yeah.
We have nothing against ROs. We run our ROs. They have a purpose,
Yeah.
but we don't believe the purpose is on this particular site.
And that certainly is the import of that correspondence, the first of which was April 2024, of looking at that point of alternatives. So that's quite, so it moved on then to that discussion that we will come to talk about at a slightly later part of the agenda, which I think is going to be quite important in my mind, but you know, leaving that to one side. So that's where that sort of whole background was that led to that situation, and I think you really
Yes,
want
just
to say something
just to locate, there was mention of, I think it was described as a significant breach of General Condition 7.1.1. For the appellant, just to locate its response, just to locate its response to that contention, that was addressed by the consultants Colmert in the report to which we've referred already this afternoon, at page 27, internal, paragraph 4.2.6. I don't think you need to turn it up, but just to record. Yeah, it is argued, I'm quoting, that there is no significant non-confirmation of condition 7.1.1, which can be attributed solely to the discharge from the site. And as Mr. Martin said, that then led to what we'd hope would be a discussion. A flavour of some of the narrative provided both by SEPA and by Mr. Martin can be seen again perhaps in the email chains 46 and 47.
I had a look at that, and I'll look at that in detail later on. As I said, I recognise that there's no guarantee that parties can agree if they're in any area of dispute, but that's been very helpful in giving a sort of an explanation as to why that stage wasn't reached. In the discussion around the suggestions that I alluded to earlier on, that for understandable reasons, FCC's consultants were looking at the whole data set more rigorously and more thoroughly, more robustly, if you like, but the suggestion that SEPA weren't. Was that part of the discussion, to say to SEPA, why aren't you looking at it? We have this information, and ours is rigorous information, ours is detailed information, but we come and do a bit more, or was that not part of the discussion? If that wasn't how it was, just say.
The only real discussion over discharge was in the meeting in Greengairs, which I said we got very fractious. It was very much down to disagreements over how you interpret the information, how you undertake an ecology survey, etc., etc. So there's very little there about this is what we need to achieve, how are we going to do it. In my view, it was there.
I was going to just turn over. Is there any comment on this for completeness?
Just to make the points, the email chains that are provided as FCC 46 and 47 certainly show that it's not the case that SEPA was doing nothing about it. They're from 2022 and 2023. That I would suggest shows the opposite. There was detailed comments provided back, and I believe that led to subsequent discussions about those reports. So that was very much SEPA's assessment of it, and having that two-way conversation about the reports. So in terms of the limit values that were then in the draft permit, as you see from the lengthy exchanges that then went on with the appellant's consultants at ESA, that there was obviously detailed consideration of that, and the correspondence there really focuses on the treatment techniques to achieve those limits rather than actually challenging the limits themselves. So,
if I may jump in as well, just to explain the reasons why we have kept our both our chemistry reports quite short and to the point in relation to the assessment of the data, WPA, WPB, and WPH, and also the SEPA data at 602, 612. The reason we focused on those aspects is because that is where SEPA felt is that is legally the assessment point where we have to undertake the EQS assessment. We recognised that there was a wider data set that was available to both SEPA in terms of our own monitoring data and provided by Colmart in their report. As I explained earlier, that was information that explains how the, if you like, the chemistry and the ecology changes over a period of time beyond the assessment point, but that assessment point at WPB was considered to be the assessment point, and we didn't want to get distracted in our reports by the other data which we didn't feel was pertinent to the triggering of the permit review. So I just wanted to reiterate that point. It's not that we, I feel like if it's been suggested that we were being less thorough by looking at the wider data set, it's just that we were trying to keep it quite focused on the point at which the EQS applied in relation to assessing the discharge compliance. So we do acknowledge that there is a variation and a reduction of the concentrations over time as you move down the catchment, but it's not acceptable to impact a catchment at 10 kilometres downstream from a discharge point. You know, the point of assessment is at that point just downstream of the site, and that gives us the best representation of what impact that site is having. As we move down a catchment, as has already been discussed, there are lots of other inputs which could impact the water environment, and it's difficult to tease those things out if we use that Luggy water as the compliance point. That's not reasonable. The compliance point is at that discharge, just downstream of the discharge. So we were just trying to keep it quite to the evidence that was required. Just wanted to make that point.
My question, or the next question, relates to the question to the clients. I did allude to this earlier on, and I suggested there were sort of three sets of evidence. There was sort of the old evidence, the stuff that's back from 2019, 2020, and I'm grateful for the clarification. That was something that was seen and was aware, and that was why the external ecology experts were commissioned to do the work that they did, and that's very helpful. So there's the sort of the older information, and then there's a degree of updated information, and these straddle, these cross over. I think there's some 2020 data that has updates in it, so there's this sort of relatively recent, and then there's the now situation. So I'm quite interested in, again, from legal representatives here to say a little bit about the kind of the relevance of the past. It's a useful narrative to understand what's happened in the past and what happened in 2019 onwards. And one of the arguments of the appellants is actually this is disproportionate as much as anything else, because actually you're imposing these requirements when actually the history suggests there's a good level of compliance, at least for certain parts of the area as concerned. My question, I guess, is why it is that anything other than the most recent information, the position now, is the key information that we need to have and make a decision on. If it were the case, and I think part of the precognition we saw are suggesting a reducing level of pollution, but the key impact I would have thought is now, and that history is useful and interesting, but it's actually the position at the most bang up to date that really is the thing that we should look at going forward. So I'm quite interested in just hearing what parties think about the weight that should be placed to the historical position, if it was the case that the historical position, which SEPA clearly took the view that it was.
Sorry, I wonder before myself and SEPA address that, you talk about the historical information and then the more up-to-date information. My understanding of the information, and again I may be wrong, is that we have the data 19, which you, sir, don't have.
Yeah.
The 2020 data in the Colmart report. We've got the Water Resources Unit report as well. Yes. Forgive me. Yeah. We've got the Colmart report, and then we have, and again this was alluded to a moment or two ago, a data set being collected in the late part of 24, which has been reported, the 6-monthly review and then the yearly review. Yeah. My reading of the 6-monthly review, it was reported after the variation was issued. So I just want to be clear in my own mind, is there an interim data set between the 20 and the 24? Because I'm getting slightly confused.
Yeah. Well, that's a very fair point as to what that meant.
For the avoidance of doubt, I'd agree with the latter comment.
If we can clarify. So the Colmart report is essentially the data that SEPA has made its decision on. That is summarised in our assessment of that. The chemistry data assessment summary is the SEPA document 13. It has had some updates to it, but it doesn't change the original assessment and how we calculated the limit values based on that for the purpose of the permit review. The separate documents, SEPA 16, which is the interim review of the 2025 monitoring, and SEPA 22, which then is from the January report, and that provides the whole year monitoring. That monitoring was undertaken by SEPA just to have a picture of the ongoing picture, but that was not part of our decision making for the variation. No. So that's really just to, obviously if that had come back showing there was no issue now, then we probably wouldn't be here, would we?
That's the case. That's what I'm driving at, is that it must presumably be the case that, or it doesn't have to be the case, but it presumably can be a relevant factor that what we're seeing is whatever might have been the case in 2019, if the trend is a trend that takes you towards improvement, if it doesn't take you towards improvement, that tells you one set of things. But if it leads you towards a sort of a level of improvement, for whatever reason that could have happened, and it could be the technology that's used, it could be any number of reasons, then that does strike me as relevant. So trends are probably important, but it still is presumably the case that there needs to be, if you like, a failure now before the obligation can be justified as being relevant to impose.
That data is showing that our most recent monitoring is still showing that there's significant breach of those EQS that led to the decision of here. I should just also mention finally the data, the SEPA 23 as well, which was the data summary, and that's the monitoring data from the operator based on the table 12 limits. now that are in there. So that's just summarising the data that they provide to us as quarterly returns. And again, that was just provided in terms of your questions regarding ongoing compliance, but also just because now at least because we have that in the permit in Table 12 now, we have that monitoring as well coming in, submitted to SEPA. So we have both our own monitoring carried out in 2025 and we have the ongoing monitoring that's now being submitted as a requirement under the permit.
So there is that. I think I know what the appellants would say to this, but what would SEPA's view be if it was shown there was a poor history and there was still some compliance, failure to comply now? Would the poor history be a relevant factor for me to take into account in deciding what to impose by way of restrictions just now? So yes, let's hypothesise there is a justification for restrictions. Is the fact there's a bad history of poor compliance in the past, is that a relevant factor? And if so, what weight to be placed if it were to be shown, if it were to be established that a site has a poor history? How relevant is that to taking into account future?
So
Not to kind of punish somebody, obviously, that would be inappropriate.
it's a question of what you're using as your input data then for the calculation of the limits that we've put in Table 13. So we've based that on the 2020 data. Yes, you could say that you could use the more recent data that we have now from our own monitoring, but whether that would change the outcome, that might be a small difference, but there's still going to be need for limits. So it's not a question of, I suppose, the history, it's just the data point that we took to make that calculation.
So it's a data point rather than drawing the conclusion about the history, which should potentially be unfair on the appellants. Which is why I think
I think, sir, you anticipated my answer. Past history would not entitle you to ignore the data or indeed ignore the submissions made in relation to justification.
I mean, the flip side of that is the extent to which, if there's a good history and this is a situation where there's a blip just now, then that may, it wouldn't impact on the outcome and the justification, but it might impact on the remedy.
Correct.
On what actually is necessary to ensure compliance.
Correct, I would agree with that, sir.
Sorry, I would just add that if we were then looking at the more recent data, if you were effectively taking a snapshot and making a fresh decision, you'd have to also then look at, I think there have been things that have happened since, for example, we understand from the site visit that there have been trials that have been conducted to use the RO unit, the reverse osmosis unit, to treat part of the leachate. So that might have reduced the discharge or might lead to some of it, changes in data as well. So
might lead to an impact.
And
What happens next? If there's are there any other items we could quickly address this afternoon before retiring and looking to go through the rest of items 3 tomorrow, and then on to some of the challenging issues in items 4.
I wonder if would item 3.7 be a quick one to knock off to do? I think that is
dealt with now, as opposed to the 4th of March issue. I put it italics as a possibility.
I know you had put it for the 4th of March, but I think actually certainly our expert that we would have appearing on the 4th of March wouldn't be talking to that. It's not specific to the ecology evidence, it's really about the classification, and my understanding is it is agreed between the parties in the joint note anyway about the classification.
That's helpful.
It's more about the approach to where you're assessing.
I am inclined probably to draw to a closing now at this stage. I think probably giving us a good going over as far as today's concerned, and then we can resume at 3.6 if there's anything very much said about that, then on to 3.10 onwards, and carrying through the rest of the issues there as we can do before we then reconvene. And would that be okay for 10 AM tomorrow morning? Mm-hmm. Yeah. If the weather permits, weather allows us to travel from wherever we are going to be tonight. So.
Sorry, could we add that we cover also 3.4 tomorrow?
Well,
We haven't actually come back to that one.
We have, yes, we have. That's true. We should. Yeah, this is the question about the limits. Maybe start with that. Try and keep ourselves in order. So 3.4, 3.6, 3.10.
Sorry. Sir, I thought I'd made it, maybe I wasn't making myself clear. The number crunching is not disputed. What one makes of that, of course, is yeah.
So sorry, just to clarify. So the actual, because I mean the joint note suggested that our application of our methodologies and models was disputed. Is that position changed now?
Is it at point B only?
Yeah.
Only ever at the discharge point? It's that. So the numbers aren't at dispute, and the point of anyone is whether only point B matters.
Only point B of
So WPB, whether WPB is the assessment
Whether
point
that-
or
okay.
further downstream.
Yes. Going back at point 3BB, we failed EQS. That is at the end of the all.
okay. So the actual, in terms of how we've gone through that whole calculation to reach the limit that goes into table 13 is
Except it's a model.
yeah. Okay.
That's accepted. But you say that's not enough. That's not game set and match. We stop now. You need to go on.
Well, we're back to the point I was making earlier on there. If we're not careful, every discharge moving on receipt of the surface water has to meet EQS. Therefore, it's very easy to regulate. Every discharge in the country gets EQS. And it's imposed, problem sorted. And I don't think that's really what we're trying to achieve.
I think it's probably useful tomorrow to go through some part of 3.4, even if we don't go through the whole model and number crunching, but certainly in terms of SEPA's policy and how we apply that and how we do that assessment at that point, and in terms of determining where we put a discharge limit is relevant to.
Yeah, we can certainly do that, and we'll see. Hopefully we can get through all the other items tomorrow, and then deal with the following issue. Okay, that's fine. Thank you.